Good morning to one and all, and welcome to the International Conference on Aviation Financing, UNIDROIT, and Growing Concerns, organized by the Center for Aviation and Space Law of the West Bengal National University of Juridical Sciences. The aviation industry has been expanding at an exponential rate for the past few years, but it has also occasionally had difficulties, which has led to discussions about a wide range of issues, with aviation financing being one of the key issues. Aviation finance is a form of asset finance which is quite different from other types of finance as it has certain unique nuances of specialized legal and structural specificities. Cross border issues exist, and depending on the environment, they may give rise to a variety of regulatory considerations unique to their own particular circumstances. Finance for aviation is heavily influenced by tax leasing, insurance, and even political factors. Furthermore, since the COVID-19 pandemic, hello high water clauses have gained added relevance while posing new challenges. So, the Center for Aviation and Space Laws is therefore hosting an international conference to discuss the difficulties associated with financing the aviation industry, the reach and impact of the UNIDROIT and the relevant domestic legal systems in addressing the pertinent issues, as well as the potential future implications for the involved public and private stakeholders. I once again welcome everyone to this conference, and I now request our Honorable Vice Chancellor, Professor N.K. Chakrabarty, to give the welcome address. Dr. Chakrabarty has established himself as a researcher in the field of criminology and criminal justice in India. He has successfully guided 22 PhD scholars, mainly in the field of criminal law and criminal justice. In 2017, Professor Chakrabarty has been awarded the Professor K. Chokalingam Award by the Indian Society of Victimology for his contribution to victimology in India. Dr. Chakrabarty has so far authored 7 books. He has also published more than 100 articles and research papers in various national and international journals. With this, I hand over the dais to Professor N.K. Chakrabarty to give the welcome address.
Thank you, Nanda, and very good morning to all of you. It is my pleasure to welcome you in our INUJS, popularly known in India, West Bengal National University of Juridical Sciences, Kolkata. Our university, which was established under an Act of State Legislative Assembly 1999, and its academic activity started 2000. And we have now established our academic quality and also contribution in Indian legal development, particularly our faculties and students, known to the legal fraternity in the country that they have the not only inclination but the capacity to add new knowledge which recognized not only in the literature but also in the judiciary also and also in the profession. I am very much happy to welcome you all in this university. We are now among the top 5 law schools in the country. And welcome all the delegates present in the web e-seminar or conference, which is organized by our Center for Aviation and Space Laws. And I am very much glad and privileged to extend my hearty welcome to the resource persons, particularly Dr. Hamza Hamid, the legal consultant at UNIDROIT and co-chair of Space Generation Advisory Council, Professor Dr. Stephen Truxell, Director of International Institute of Air and Space Law, Leiden University, Professor Anna Masutti from University of Bologna, Dr. Attila Sipos from University of Sharjah, Mr. Aditya Bariat from MNLU Mumbai, Professor Dr. Patrick Onibear from University of Mississippi, Dr. Dibba Tyagi from Gujarat National Law University, Professor Laura Piralini from Studio Piralini, Italy, and Dr. Andrea Trimarchi from University of Cologne for having made time for joining and contribute to the knowledge and discussion or debates on the area of this aviation financing. I should also go to some record and inform the delegates that our center, the members and the director, they are working hard for last 2 years in spite of COVID situation. They are working online virtually, and last 2 years our center now globally visible, and the center blog Lex column is continuously receiving submission from experts across the world, and we have also published an edited volume National Space Legislation through the Thomson Reuters India last year. I wish all the best for the center and hope this center will flourish as one of the best centers in the world. The theme of this conference is very much contemporary and significant, particularly in the aviation sector. And we know that economy in the world development is very much discernible from various government policies, and there is a need to have a policy in this aviation sector also. The UNIDROIT system has tried to bring such confidence in the minds of creditors so that the aviation sector would not suffer from the lack of financing. There is a doubt in the minds because in aviation sector requires huge amount of financing. Unless there is potential investors, the confidence building is a question, and it requires confidence among the investors. The problem of aviation financing have not stopped here, and there is no universal acceptance of UNIDROIT system, but there exist other difficulties in the implementation of the system. And we also to mention that COVID-19 has added the difficulties and the concern about aviation financing sector. I hope this conference intends to map the nuances of aviation financing and may focus on certain new ideas, focus on how UNIDROIT's efforts and continuing the problem of financing of aviation can be addressed properly. While few experts work in this super specialized domain, there is a requirement of creating awareness among various stakeholders of aviation financing. During this discussion and fruitful comments and interaction among the various experts and the participants, I think there would be an opportunity to develop some points which may be considered by the policymakers. I once again express my thanks and gratitude to all the delegates, particularly the resource persons, and also to my director of the center and its members who are working hard to make this conference during last almost more than 1 month. They are trying to make it a effective one. I wish all success of the conference, and I hope the experts' contribution would be recorded and there would be some publications in your blog or in the form of book or a monograph which will add to the literature of air and aviation. Thank you all for joining. I take the opportunity just 1 minute that I have in our university another program at 10:30. I would not be able to continue. Take your leave another 15 minutes or so, and then I have to join another because today we have three programs. Our teachers, students are enthusiastic in looking into various problems, developing issues, legal issues. I am happy to see they are working in the legal field and contributing in the legal literature. Thank you all once again. Thank you.
Thank you, sir. I would now like to call upon Professor Sandeepa Bhatt, Professor of Law and Director, Center of Aviation and Space Laws, NUJS Calcutta, to give the opening remarks on the topic of outlining the concerns in aviation financing. Before he begins, I'd like to give a small brief about Dr. Bhatt. Dr. Bhatt is a member of the Board of Advisors of the Global Network Against Weapons and Nuclear Power in Space in Brunswick, United States of America. He also has the distinction of being a member of the American Society of International Law, Baltimore, USA, the International Academy of Space Law, Moscow, Russia, and the International Institute of Space Law, Paris, France. He holds the unique feat of being the first Indian to be inducted as the UNIDROIT correspondent for India. Dr. Bhatt has published 4 books on space law, and in addition, he has published more than 50 articles in journals of international and national repute. He also has the distinction of being a member of the Indian Space Research Organization's expert group for drafting the National Space Act for India. Over to you, sir.
Thank you, Aisri. I hope I'm audible. Aisri, can you just confirm?
Yes, yes.
So whether my screen share is visible there?
Yes, sir, it is.
Yeah, all right. Distinguished Vice Chancellor, sir, our resource persons for today. Of course, very few I know, because as our Vice Chancellor, sir, has rightly pointed out in his welcome address, there are very few who work in the field of aviation financing, and getting experts in this field is really, really difficult. And I'm fortunate to have them actually. So best of the best experts across the globe we are having as the part of this particular conference. My dear colleagues and friends, a very good morning to all of you. I should also actually thank our Honorable Vice Chancellor before he leaves, because actually he has always been a pillar of strength for any activity in NUJS, not just of actually our center's activity. At any point in time, whenever we have asked for actually any approval with respect to anything, he was the first person to come forward and actually accept those things. So I should really thank him for his continuing support, and I hope that actually we live up to his expectations, not just in this conference and also actually in the coming days. Now, as far as the aviation financing is concerned, there are a plethora of issues, but let me actually, as a kind of a introductory to this entire seminar, let me just tell or focus more in terms of what are the concerns which we are facing at present with respect to financing in the international level. Probably most people might not even be knowing about it, because as I told, actually, very few experts actually practice in this particular field. And we have the best of the best practitioners as well as the academics who are being part of actually this particular conference today. Aviation sector requires huge investments, maybe running into a few $1 billion. Be it actually the airport, be it actually the aircrafts, purchasing of the aircrafts, or maybe leasing of the aircrafts, or even actually the other infrastructure which are required for the purpose of civil aviation would cost huge amount. There are some cases wherein the state has tried to come forward with the support. In fact, actually, Professor Stephen Truxell is supposed to speak in this inaugural session on the state support. And that state support has been challenged at the WTO level. There have been actually problems. So probably Professor Truxell is going to address on that. On the other hand, even in terms of private investments, there have been serious problems. Because the traditional financing doesn't work here. It's a huge investment. And unlike in the traditional case, wherein you have a collateral to pledge and get the loan for the purpose of carrying on the activities, it doesn't happen in the aviation sector. In case of small investments, maybe one can pledge collateral like the gold or maybe land property to the bank and maybe get finances. But since the investment is huge here, and also most of the airlines or the aviation players would be the startup companies, they would not be having the collateral which is valuing that much of amount to pledge. Few $1 billion, how can actually they pledge any asset? They would not be having that asset to pledge. So therefore, what functions in the aviation sector is asset-based financing. That is, the asset which is being financed itself is used as a collateral. Like the aircraft which is being financed, that itself is being used as a collateral. Probably, if I have to actually draw a parallel in the Indian context, best thing which you can see is the hypothecation. ABF is almost similar to that of hypothecation. Most of us know loan provided with the bank with respect to the vehicles, whoever is purchasing the vehicle. The owners of the vehicle might not be having anything else as a collateral. They will pledge the vehicle itself, which they're going to purchase, as the collateral for the loan. Many of you might have seen in the cars or maybe in the buses, hypothecated to XYZ bank. Hypothecated to XYZ bank. That would be actually the sticker would be there. That means actually there is a loan which they have procured from a bank, and the vehicle itself, which has been purchased out of the loan, is hypothecated to that bank. So that's how the asset-based financing works, or maybe the hypothecation works. And it's a kind of a non-possessory security interest. Creditor is having a kind of a non-possessory security interest. I mean, unlike in a traditional financing, right? Say in case of traditional financing, like say for example, somebody is actually taking a gold, pledging it in the bank. Bank gets the possession of the gold. The creditor has the possession of the gold, and then it lends the loan to the debtor. So possession is with the creditor until the loan is paid back by the debtor in the traditional financing. So it's a possessory security interest. But on the contrary, in a non-possessory security interest like this, the vehicle or the aircraft would be possessed by the debtor, the airline company, or maybe the owner of the vehicle. They would be having the possession of the vehicle, and the creditor, maybe the bank or maybe any other private investor, would only be having a non-possessory security interest because he's not having the possession of the collateral. Only when the debtor makes the default, the creditor gets the right and possession transfers to the debtor to the creditor. So that's why it's a kind of a non-possessory security interest, which you can find in the asset-based financing or even in case of hypothecation. One of the first problems which arises out of this non-possessory security interest is the recognition. Unlike a common law country like India, many countries don't even recognize the non-possessory security interest. Right? We do recognize, true, but some countries don't recognize, they don't enforce the rights of the creditors in case of a non-possessory security interest. Or alternatively, even if they recognize, they would recognize it to a very limited extent. Certain kind of remedies would not be available actually. So that's why we are at actually different stages. Some countries fully recognize the non-possessory security interest, some do not recognize, and some others are somewhere in between the two. So creditors would always be having a dilemma by virtue of this in any case of a non-possessory security interest. And this is furthered by the fact that aviation financing would always be cross-border. It would be having the cross-border actually the implications. Because huge finances, you can't expect that much of financing coming from creditors within one country, within one jurisdiction. You can't expect that. For example, if aviation sector or maybe an airline is actually being started in India, that airline company might be getting the finances from different creditors, maybe from one from Canada, one from Japan, one from Russia, one from United States. It goes on. List goes on. You don't know from where and all the finances are actually procured by the debtors for carrying on the aviation activities. Now, this brings in the question of jurisdiction and applicable laws at a time when the debtor makes a default to the creditors. If debtor doesn't pay back the money, you have to find out which is the appropriate court to decide that particular dispute and what law we are going to apply for the purpose of settlement of any dispute between the debtor and the creditor. So jurisdiction and applicable law becomes problematic. I can contemplate two scenarios with respect to this. One, a scenario wherein the contract between the debtor and the creditor doesn't mention about the jurisdiction and applicable law, right? They might not mention. Second, they do mention, right? They mention that this is the applicable law. This is the court which has got the jurisdiction in case of any dispute between the creditor and debtor. There is a possibility of actually both scenarios. And in both scenarios, there are problems. In the aviation sector, there are problems. First, wherein the creditor and debtor doesn't agree for the jurisdiction and applicable law in their contract, we have to obviously fall on private international law or conflict of law for the purpose of determination of the jurisdiction and applicable laws. We have to look into the principle of conflict of laws. If you look into the principle of conflict of laws with respect to tangible movables, that is the tangible objects which move from one jurisdiction to another jurisdiction, like the aircraft, right? Those which are flying international destinations, which move from one jurisdiction to another jurisdiction. So in case of tangible movables, what is applicable is lex fori with respect to jurisdiction, lex loci with respect to applicable laws. Lex fori in the sense, the code of the state wherein the object is found at the time of cause of action, at the time of default. Cause of action here would be default by the debtor, right? So at the time of the default by the debtor, where exactly the aircraft is located, that particular country's court would be having the jurisdiction under the lex fori. Lex loci says that that country's law is applicable. Wherever the aircraft is found, at the time of cause of action or the default, that country's law is applicable for the purpose of determination of the rights of the creditors. This is really problematic. This is really problematic because the debtor can misuse the position. Simple thing is that they can go for a default at a time when the aircraft is in a place which does not recognize the non-possessory security interest. I told you already that non-possessory security interest like ABF is not recognized in some jurisdictions. So if the debtor makes a default at a time when the aircrafts are there in a jurisdiction which does not recognize the non-possessory security interest, how can the creditors enforce their rights? Because you are applying lex loci, law of the place where the object is found, or maybe the aircraft is found. So under that law, there is no enforceability. So creditors' interest would be defeated by virtue of that. That's the problem when you don't stipulate actually the jurisdiction or applicable laws in the contract. But on the contrary, if the contract mentions also, if the contract stipulates the jurisdiction and applicable law, even in that circumstance, there are problems. There is a twofold problem. One is the transparency, because suppose if Indian debtor, that is the airline, has already taken finance from a Canadian creditor, then subsequently Japanese creditor, now they are seeking from a Russian creditor. The Russian creditor would not be knowing how many prior existing interests are already there. How many creditors have already financed, how many people are having interest over the asset, because asset is one, right? How many creditors are having actually interest over that, they would not be knowing. They're all the private contracts. Unless the debtor is actually revealing it to others, there is no possibility of the subsequent creditors getting to know about how many interest holders are already existing. So transparency is a problem, right? Only common person is the debtor. Creditors are all different, private individuals. So how do you know about already existing contracts or already existing interest? Number one. Number two, in each of these contracts, as I told, independent contracts, like the Indian airline having a contract with the Canadian creditor who might have financed hypothetically $10 million. Then subsequently a Japanese creditor, $20 million, Russian creditor, 40 million. Like that, actually, there might be different, actually, the independent contracts with respect to financing. Now, in each of these contracts, there is a possibility that the parties have agreed for different jurisdiction and different applicable laws. Indian debtor vis-a-vis the Canadian creditor, there might have been agreement that the Canadian law is applicable. Indian debtor vis-a-vis Japanese creditor, they might have agreed that the Japanese law is applicable in case of default. As against the Russian creditor, they might have agreed that Indian law is applicable in case of default. US law, something like that. There might be different applicable laws which might have been agreed in the contract between the debtors and the creditors. Please keep in mind, all these applicable laws are different. There is no uniformity. The financing laws are different in different countries. There's no uniformity in it. Now, in case of a default by the debtor, as against the creditors, all the creditors, he fails to pay back the money to all the creditors. Very next question is that who will run first in the priority? Right? Because usually when the debtor fails to pay back the money, value of the asset would be less than the liability which he is having. If there is a liability to the extent of $1 billion, debtor has actually taken the loan to the extent of $1 billion from different financials, right? And he has the asset value of only 500 million. His aircrafts are worth of actually only 500 million. When the creditors are trying to enforce their right against the asset, that is the aircraft, there would only be 500 million available. Remaining 500 deficit is there. Those who get back the money would be those in the top of the priority. Whoever is getting back the money first, they will get back. But those who are in the bottom of the priority would not get back the money. So everyone would like to run into the priority. Every creditor would like to run into the priority. And if you look into the various jurisdictions, they have the different norms with respect to priority. Some of them may have a norm like first come, first serve. Whoever was the first financer would get back the money first, then second, third, fourth, fifth, like that. Some of them might have a norm with respect to distinction between secured creditors and unsecured creditors. Secured one would get first, unsecured would at a later point in time. Some of them may have a system of registration. Whoever has registered first would get back, subsequently the next like that actually. Or unregistered would get it towards the end. Even though they were the first financiers, still they will get towards that. So that is how there would be problem in terms of the priority, resulting in a situation of a chaos. Right? So Russian player might say that, no, you have to go by actually registered and unregistered. I have registered in Russia, therefore my right has to be enforced first. Canadian creditor might say that I'm the first person to actually finance. Canadian law says first come, first served, apply the Canadian laws. So that's how there would be problems in terms of actually the applicable the laws, since different applicable laws might have been agreed upon in different contracts. So this is the major problem which is there in the aviation financing. And all of us know that any investor would invest in any sector only after making a proper assessment of risk benefit. Risk and return, right? So they have to actually weigh and balance between the two, right? So they need maximum benefit with minimum risk. Even if the benefit is more, but on the contrary, risk is also more, most of the financiers might not be interested to invest. Even if returns are more, risk is another important factor. So they will weigh and balance. So these aspects, what I have already pointed out, indicate a huge amount of risk, creating a confusion in the mind of the creditors. They will not be actually willing to finance the aviation sector. That is the very reason why the UNIDROIT started working in this direction. UNIDROIT is primarily for the purpose of unification of the private laws. It works in that regard. Hamza is there here. Actually, he is representing the UNIDROIT Secretariat. He would be explaining more about it. So it worked in this direction. and came up with a two-tier structure in terms of the financing, especially with respect to mobile equipments, those which move from one jurisdiction to another jurisdiction. A two-tier structure consists of a base convention, the Cape Town Convention of 2001, and it is supplemented by 3 area-specific protocols. Because the mobile equipment at present primarily include aircraft equipment, railway rolling stock, and the space asset. These are the 3 which have been identified right now. So on these disciplines, there are 3 separate protocols, and base convention is applicable and has got all fundamental norms for all 3. Some fundamental norms are together which are put in the base convention. Aircraft protocol has come into force, but unfortunately the other 2 have not come into force. So only in the aspect of aviation financing, we can find that there is a system functioning under the UNIDROIT. It's a 2-tier structure. We have to read the Cape Town Convention along with the aircraft protocol for the purpose of understanding the UNIDROIT system applicable for aviation financing. And this system is primarily, as UNIDROIT itself proclaims, that it's a sound legal system to facilitate creation, perfection, and enforcement of the security interests. Right? Because what it does is that it helps in terms of creation of an international interest. Even though the creditor and debtor are from the same jurisdiction, still an international interest can be created in favor of the creditor, despite the fact that it is not recognized by the municipal law. You can create an international interest which can be recognized under the UNIDROIT system. One can perfect the interest through the registration, right? Through the registration, which provides the remedies to the creditors actually. So they can perfect their interest, and then they can also enforce their interest, because the UNIDROIT itself provides for independent remedies. The system itself provides for independent remedies, even though they are not recognized under the municipal law, right? That's how actually, even in case of insolvency, remedies are available to the creditor. So that is how UNIDROIT is trying to build a kind of a creditor-friendly system wherein the creditors can have a kind of a confidence in terms of aviation financing. So this is what is the background about the aviation financing. There is a serious concern UNIDROIT has tried to address, but despite that, there are still certain other issues which are still going on in the aviation the sector, and things like COVID-19 are adding on to the problem actually. So anyhow, in today's discourse, I'm pretty sure that actually there will be many presentations and resource persons discussions on all these aspects. And that's all from my end. Thank you so much. And I hope that all of you would be enjoying all sessions today and enriched by the end of the day. Thank you so much.
Thank you, sir, for setting the stage in a way for this conference and shedding light on the current challenges and issues that exist in the aviation financing arena. Our next speaker is Dr. Hamza Hamid. Dr. Hamid is a legal consultant at UNIDROIT in Rome, Italy. He is also the co-chair of the Space Generation Advisory Council. Dr. Hamid's work is focused on secure transactions law and fintech, wherein he works on the Cape Town Convention and its protocols, with a particular focus on spacecraft financing, as well as the UNIDROIT's project on digital assets and private law. He also coordinates most of the activities of the Cape Town Convention academic project and is the manager for fundraising and administration at the UNIDROIT Foundation. He will be providing the keynote address on the topic of aircraft protocol of the Cape Town Convention from the UNIDROIT perspective. Over to you, sir.
Hello, good morning, and I hope you can hear me and see my slides. Thank you very much for the kind invitation, and thank you for that kind introduction, Aisri. Before I start, I'd just like to very clearly point out I'm certainly not a doctor yet, and but very happy to be here at this conference amongst very well-distinguished professionals, colleagues, and friends to talk a little about the aircraft protocol of the Cape Town Convention. Before I start, I'd like to expressly thank Dr. Bhatt for all of his kind efforts and work towards further promoting the work of UNIDROIT in India and in different parts of the world. As was mentioned early on, Dr. Bhatt is one of UNIDROIT's correspondents and correspondents for us are incredibly important, as they serve as ambassadors of the Secretariat and of the institution in different parts of the world and contribute to the success of our instruments. And for that, we're very, very grateful. I think, today's conference is very important, and the subject being discussed is of an incredible amount of relevance. And I thank Dr. Bhatt for setting the scene for how difficult aviation finance can sometimes be, and some of the challenges associated. As indicated by the program, I'll talk a little about the aircraft protocol of the Cape Town Convention from a UNIDROIT perspective. And then having looked at the rest of the program, I see that various other colleagues will talk to you about some ongoing issues, particularly with regard to enforcement and domestic implementation of the treaty, as well as contractual issues. So with that, given that the title of this conference very much relates to the activities of UNIDROIT, I thought I would start with a short slide on outlining some of the history of UNIDROIT to those that might not be aware of the organization. UNIDROIT was established in 1926 as an auxiliary organ of the League of Nations. UNIDROIT is headquartered in Rome, in Italy, which is where I am based right now, and comprises 63 member states from all parts of the world. These 63 member states make up more than 73% of world population and more than 90% of global nominal GDP. As Dr. Bhatt mentioned earlier, the primary purpose of the establishment of UNIDROIT was to develop methods for modernizing and harmonizing commercial law and private law, with a particular emphasis on increasing cross-border transactions, giving greater certainty in international business activities, as well as to develop uniform law instruments, principles, and rules to address private law issues. The idea was to bring together legal minds and thinkers to recollect how private law issues are addressed in different parts of the world, and then to create a unified instrument to address them accordingly. When you think of international law, you always have to think of the public international law side of things, which is the law that governs activities of governments amongst each other, and the international private law side of things, which is international law adopted by governments but applicable to private citizens within the government's jurisdiction. And that is what UNIDROIT entirely works on. UNIDROIT's work facilitates trade, contributes to international sustainable development, promotes education, advances international cooperation and exchange, and closes cultural gaps. And we have members from all around the world, including South Asia, whereby most of the major economies in this region are part of the UNIDROIT statute. The Cape Town Convention, or officially known as the Convention on International Interests in Mobile Assets, is by far UNIDROIT's most successful treaty that it has adopted in its close to 100-year history. I start off with this map, which showcases the wide global adoption of the treaty, with the convention presently having 83 contracting states and having also been approved by the European Union. In fact, this number is already outdated. As I found out just yesterday, we are processing the 84th ratification, and so we need to update this map in a few days. These jurisdictions represent almost every major or most major aviation economies in particular, given that the Cape Town Convention has this two-tier system, which was described a little earlier, such that it has a head convention and then is supplemented by protocols. So in the process of putting together the Cape Town Convention, the drafters identified several industries, and in particular these four, which were in need of instruments or an instrument related to cross-border financing of high-value assets. Now, these subsequent protocols of the Cape Town Convention were developed to address specific needs of financiers and industry participants in these various industries. So I know Dr. Bhatt already mentioned the aircraft protocol, which applies mostly to airframes, only to airframes, aircraft engines, and helicopters of a certain size. The Luxembourg Rail Protocol, which particularly applies to railway rolling stock from high-speed trains to commuter trains, trams, metros, airport trolleys, etc. The Space Protocol, which applies to space assets, satellites, and their components. And the most recent addition to the Cape Town Convention family, which is the 2019 Mining, Agriculture, and Construction Protocol, which is designed to apply to these three different industries and provide certainty in financing of assets in these sectors. Now, it's very important to understand this two-tier structure in order to understand the way the Cape Town Convention works. Essentially, when a country wants to help its industry or facilitate its industry to access the remedies available under the Cape Town Convention system, it has to become party to the convention and the relevant protocol that it wants to adopt domestically. So the most successful of the four protocols, as was already mentioned, is the aircraft protocol of the convention. So the aircraft protocol, as you can see on this map, has 80 contracting states, including the support of the European Union. And its success can be measured by looking at the amount of registrations that take place in the international registry. Now, we'll talk a little more about the international registry in the next slide and what the purpose of the Cape Town Convention and its various protocols is. But as Dr. Bhatt already alluded to, when you think of secure transactions law and when you think of a system of priority rights, most jurisdictions around the world allow for the perfection of priority rights. And by perfection, I generally mean the capacity to be recognized in court. So the perfection of priority rights by means of registration. For the Cape Town Convention and its various protocols, what was created was the concept of an international interest, which is an interest that is applicable or acceptable in all contracting states of the convention and the relevant protocol. These interests are then registered in an international registry, and registration in which is recognized across all contracting states of the treaties. The registry for the aircraft protocol, since its establishment in 2006, has had more than 1.3 million registrations across more than 300,000 aircraft assets with an estimated collateral value of more than 650 billion US dollars. This exemplifies the success of the aircraft protocol and outlines that a large number of aviation finance transactions, particularly leasing transactions, are conducted using the Cape Town Convention system, and these leases are then registered thereafter in the registry for the aircraft protocol. The benefits of the Cape Town Convention can not only be quantified in terms of registrations and registry activity, but can also be seen by looking at the recognition of the treaty by different agencies and organizations around the world. In fact, a key element of the success of the Cape Town Convention and its aircraft protocol is what is called the OECD discount for countries which abide by or have implemented the Cape Town Convention and its aircraft protocol in a certain manner. This OECD discount relates to an understanding between export credit agencies that are part of the OECD's export credit group, which all collectively offer up to a 10% reduction in transaction costs to operators of airplanes in states that have adopted the Cape Town Convention and have made the relevant qualifying declarations for this discount. This is a big deal. If a country is eligible to have its operators be subject to the OECD discount, airlines and airplane operators within that jurisdiction can access credit at a much reduced rate, thereby allowing them to participate in more commercial activity. The aircraft protocol has improved credit ratings and recourse to market debt financing, as well as offered better conditions for commercial credit, including leasing operations. In fact, a study showed that the entry into force of the Cape Town Convention has reduced the cost of financing airplanes by more than 30%. And if you think of aircraft individually, if you look at the financing of a typical ATR 72 aircraft, a study showed that the cost of financing an ATR 72 aircraft in a Cape Town state was generally $330,000 lesser compared to a non-Cape Town state. If you scale that to an Airbus A380, then the costs of financing that airplane was more than $2 million less compared to a non-Cape Town state. Other than adoption globally, the Cape Town Convention and its aircraft protocol also have private sector support across the board. So financiers, lessors, lessees, and operators all participate in what's known as the Aviation Working Group, which has a statutory objective of facilitating the advancement of international aviation finance and leasing, primarily through the Cape Town Convention, and to address inefficiencies in aviation finance or leasing that constrain these transactions. You can see a full list of members of the Aviation Working Group on the link that I've put in on this slide. So why was the Cape Town Convention developed? I think a lot of this has already been spoken about by Dr. Bhatt, so I will not spend too much time on this slide. But essentially in the late 1990s, there was an exponential growth in aircraft traffic, in air traffic and in the aviation industry, and a reduction in public financial support. And I know that the next presentation by Professor Truxell will talk a little more about this. But there were also a lot of positive externalities in the acquisition of new equipment, such as, for example, greater safety of air travel, airplanes that were cheaper to fly, airplanes that were less noisy, better for the environment. However, at the same time, there existed a lot of legal obstacles in using asset-based financing and leasing, particularly in cross-border transactions without uniform law, due primarily to a lot of the issues that Dr. Bhatt described, but including traditional conflicts of law approaches, which were not always very well suited to moving assets, as well as legal systems varying in their approach to the recognition of security interests, the process of enforcement, and the remedies available. The treaty that generally was available at that time was the Geneva Convention, which, while being a great precursor to the Cape Town Convention, had some legal issues, including a slightly unclear scope, difficulties in understanding the application of the treaty to unregistered rights and interests, particularly in domestic law, as well as a limited number of extrajudicial remedies, as well as creditor protection. So this problem was presented to UNIDROIT, where the solution of a uniform legal regime created by treaty to facilitate financing and leasing of certain types of uniquely identifiable high-value mobile assets in specific industry sectors was adopted, and that gave rise to the Cape Town Convention, all of which, and its protocols, all of which aim at increasing certainty and reducing risks in asset-based financing for certain types of uniquely identifiable high-value mobile equipment. Now, I know Dr. Bhatt talked about these international interests being created that would be applied in all parts of the world without necessarily existing under the domestic law or under municipal law. The reason that these international interests would be recognized by a court of law in domestic jurisdictions, despite not having a base in that jurisdiction's own laws, is because they're implemented through treaty, right? So when a country signs on to the Cape Town Convention and adopts it as part of its domestic legislation, the idea of an international interest becomes part of that system because of that country participating in that treaty system. And that international interest then takes priority over other interests, and which might be created under domestic law or unregistered rights or interests that might exist domestically or locally. What this does is that the idea that this international interest that a creditor holds will be enforceable and will have priority over other interests that a creditor might not know about creates greater certainty. And then that reduces risk, and that lowers the costs of getting finance for airplane operators and airlines in particular. All protocols of the Cape Town Convention and the Cape Town Convention generally have 6 main features. They create this idea of an international interest, which is an autonomous international interest, and can be held over equipment, which derives either from a security agreement, a conditional sale, or a lease agreement. Each individual protocol creates a dedicated international asset-based and wholly electronic registry, which ensures transparency and predictability, as well as effectiveness against competing creditors and in insolvency. Clear priority rules by way of registration in the international registry, such that if you register, your registered interest takes priority over unregistered interests and interests registered later. Effective enforcement measures applicable also in insolvency, whereby the Cape Town Convention provides effective and swift enforcement measures, including out-of-court remedies, if contracting states so agree, and including advance relief pending final determination during court proceedings. Flexibility achieved through declarations, whereby states can make policy choices through declarations to the convention and the protocol, as well as advanced creditor protection through protocols. The system of priority under the Cape Town Convention is such that if you have a security agreement, a title reservation agreement, or a leasing agreement by way of which you have created an international interest in an asset that is within the scope of a particular protocol of the Cape Town Convention, you can protect that international interest through registration in the international registry created under that particular protocol. In the case of the Cape Town Aircraft Protocol, that would be the aircraft registry in Dublin, operated by Aviation. This registration then has priority over all subsequent registrations of international interests in that same asset, as well as over unregistered international interests and domestic law interests in that asset, with a very limited number of exceptions. These exceptions were put in place to allow jurisdictions to continue to protect the rights of parties domestically that might be impacted by the exercise of a creditor's rights. So, for example, if maintenance dues need to be paid on an airplane that is now being repossessed, something like that would take priority over the creditor's rights because they relate to consumer protection. The aircraft protocol then has 37 articles, including 2 insolvency alternatives that implement this whole idea and go deep into the details of how it functions and how it operates. Certainly isn't enough time for me to get into those, but I would definitely recommend taking a look at the practitioner's guide for the aircraft protocol published by the Aviation Working Group to understand almost all of these, as well as the official commentary, which deals with this quite extensively. Now, I know the title of this conference talked about, growing concerns about the Cape Town Convention and its applicability. At UNIDROIT, we have seen the Cape Town Convention and the Aircraft Protocol be beacons of stability and certainty during almost all recent crises that have come about. In particular, the Cape Town Convention and its Aircraft Protocol was thoroughly tested during the COVID-19 crisis, where we came across a situation in which airlines were defaulting all around the world and air traffic was at its lowest. However, thanks to the adaptability of the Cape Town Convention and its emphasis on party autonomy, all Cape Town Convention related agreements had the capacity to either be renegotiated or, in the case where a creditor wanted to exercise its rights over the assets, exercisable. We did come across several situations, not at UNIDROIT, but we observed several situations in the industry where several interesting applications of the Cape Town Convention came about. And these can be guided by what is called the official commentary of the Cape Town Convention, which helps legislators, judges, and practitioners interpret and understand the provisions of the treaty. The official commentary is a document mandated by the Diplomatic Conference for the Cape Town Convention and its Aircraft Protocol, and recently published its 5th edition. Additionally, in order to address ongoing issues, the Aviation Working Group, in support of the Cape Town Convention Academic Project, also published some additional guiding annotations to the official commentary to further help legislators understand how to implement the Cape Town Convention in particularly tricky circumstances, such as those that occurred either during the COVID-19 crisis or also during political crises that are happening in different parts of the world. It's important to recognize that greater certainty is always helpful. Clearer rules are always helpful. And the Cape Town Convention, the fact that there were agreements structured under the Cape Town Convention gave a lot of certainty and security to creditors that were party to transactions that ran into difficulty. Now, of course, being in international private law treaty, the success of the convention and its aircraft protocol depend entirely on the way it's implemented in any domestic jurisdiction. And so there were problems in different parts of the world where the Cape Town Convention might not have been implemented properly, thereby judgments leaned in different directions. But at the same time, we also observed that in various jurisdictions where the implementation of the treaty was done in an extensive manner, including training provided to the judiciary as well as practitioners across the board, good results were achieved. And I know a lot of other speakers will talk about the implementation of the Cape Town Convention later, particularly in civil law jurisdictions and also in some common law jurisdictions. So I would say that there are no growing concerns. In fact, the Cape Town Convention continues to be successful, adopted by different countries around the world. In fact, in my work at UNIDROIT, talk to governments and jurisdictions on an almost daily basis that are presently considering the Cape Town Convention and its various protocols, as they have seen the benefits that it can bring to countries around the world by giving cheaper financing to airlines, by giving greater certainty to lessors and creditors, as well as the rules relating to speedy enforcement and certainty. So with that, I know this is an academic conference, so I would greatly encourage all of the participants that are interested in the Cape Town Convention to check out the Cape Town Convention Academic Project, which comprises of a comprehensive digitized and searchable repository of all material related to the Cape Town Convention and its various protocols. It includes free access to the official commentary for academic purposes for all students and researchers, as well as organizing an annual conference that many practitioners in the industry attend at the University of Cambridge every year, In fact, these conferences often tackle some of the concerns that will be discussed today. In particular, for example, this year's conference looked at public international law and the Cape Town Convention with a focus on the political issues taking place right now. Last year's conference looked at the COVID-19 crisis and so on. So definitely recommend all of you to check that out. And with that, I will stop there. And I'm completely available for questions either at the end of the session or through email or online. And I thank again Dr. Bhatt and the law school for their kind invitation, and look forward to continuing to participate in these conferences into the future. Thank you very much.
Thank you, sir, for sort of shedding light on the UNIDROIT system and like the Cape Town Convention Treaty, the structure, its developments, the benefit it has, and also elucidating on the key legal features it contains. And lastly, for the helpful resource that you shared with us today. I'm sure that all of us will be greatly benefited from that. Thank you very much once again. Our next speaker is Professor Steven Truxall. Professor Truxall is a full professor and director of the International Institute of Air and Space Law at Leiden University, the Netherlands. He previously worked as Associate Dean International at City University of London and was visiting professor and Dean of Studies at the Center of British Studies, Humboldt University of Berlin. Professor Truxall completed his doctorate in air transport competition law in London. He has spent time on sabbatical at McGill University's Institute of Air and Space Law. Prior to working in academia, Professor Truxall held positions at Deutsche Lufthansa AG and the US Department of Commerce. I now call upon Professor Steven Truxall to give the special address on the topic of state aid and aircraft finance, a balancing act.
Hello and good morning. Sorry, I just lost my connection for a moment. Let me just share my screen. Are you perhaps able to share my slides? Because it doesn't seem to allow me to do this on this computer I'm using.
Just a moment, sir. We're working on it.
All right, perhaps I can switch to a different browser. I will try again.
Professor Truxall, can you just try once again? I have added you as a co-host now, actually, so probably.
Perhaps that was the issue.
Yeah, just check it, actually. Yeah. Tanmay, whoever is actually presenting, add them as a co-host so that actually they can share from their side. Tanmay?
Yes. So Umang was about to share the screen.
Yeah. Okay. Fine. I think now Professor Truxall can actually share it from his side itself.
I'm sorry to hold everyone up with this technological issue. I don't normally use this platform.
No problem. If there's any problem, we will actually share it from our side. No problem. Yeah.
Yeah, I think it's better, just in the interest of time. If you've got it queued up, then let's do it that way.
Umang, can you please share it? Can you please share?
Well, I will start while you're working on that. Good morning to everyone, and thank you for having me. It's a delight to see. It's quite early in the morning here, although I'm 1 hour closer to you than Leiden, the Netherlands. And I am happy to speak this morning because I've got to travel, so it suits me quite well. It's great to see also on the program so many alumni and colleagues and friends from the here it comes. From our institute, but other institutes that I had the pleasure of visiting, Mississippi being one of them. I see Patrick Honebeer is here. Hello, good morning. And also alumni, Hamza and others. So really delighted to be with you. I'm going to take maybe one step higher level. And if you can maybe make the slide slightly bigger so that it's easier for people to see. So I'm going to talk. I've been asked to speak by Professor Sandeep. Thanks for the invitation to about state aid and aircraft financing. And of course, I promise not to go on and on about Airbus and Boeing, although I will make a mention of it. But really, what I'm quite interested in sharing with you is the future rather than the past, what has plagued us in the past. And the starting point really is the next slide, which is the state and the market, which I think is always something to start and return to, which we've seen also during COVID times, of course. And there is an animation here, so it's not ideal. But can you maybe full screen this, and then you can do the animation? So the point is that we started, once upon a time with state regulation. Tight regulation, state intervention, involvement, interference, what one might say, with the market, and rather that private actors weren't, able to, or they weren't private actors able to decide for airlines which routes to fly and so on. And so we have benefited from deregulation and liberalization of markets, and that has given way to a level of autonomy for players in the market. And I think if we take that from, service providers to a higher level within the aircraft manufacturing and production, or design and production and delivery of aircraft, we can see some similarities there. And my fear, maybe fear is a big word, but my concern is that we may be moving back in the direction of state intervention, at least with the role of the state in the market. And again, I think COVID has shown that. But again, with other global contemporary challenges such as the environment, perhaps this is also needful. So I have unlike normal discussions on state aid, I actually have a kind of a positive message to convey today about state aid. If you go to the next slide, please. So just to give you, of course, we know all of these players in the market, but just to name a few. So slide 3, we have, of course, Airbus and Boeing, I've already mentioned, but then we've got the rise of Comac, the Chinese manufacturer, and some others on the screen there as well. If you could just go to slide 3, who's controlling the slides? Are you there? Can I do it? There we go. Okay, so these are the players. To name a few, while you have your finger on the button, please go to slide 4. What I wanted to talk a little bit about today is, of course, as we've already heard, the major investment is really required for, well, either from states or from private investors. And we know, if you could go to the next slide, please. Apologies for this. This is my fault, but now you're not cooperating very well with me. If you could go to the next slide, please, whoever's controlling the slides. There we go. Okay, so cost of new aircraft. Well, we know they're horribly expensive for good reason. And so this requires, of course, private finance. And we've heard from Professor Sandeep the difficulty in that, also with respect to foreign investment. And we know that creative legal solutions are required. Of course, the whole system of public air law has developed, has modernized with Article 83 bis, so that has facilitated the transfer of some responsibilities and so on to the state of operation rather than the state of registry. So that's nice to see at public level. We know about the Cape Town Convention and the Aircraft Protocol. This is also supported then, how should we say, mitigating the risks with respect to movable, with respect to aircraft as movable objects. But of course, we've seen, and we're living this unprecedented situation where, and I don't mean to suggest that Cape Town Convention or the Aircraft Protocol aren't working, but we are in a very difficult situation with Russia, of course. So how does that look forward in terms of attracting private investment? And what does it mean for insurance or the insurable risk, if there is an insurable risk for such things to happen in future? We have a lot of flexibility. We see the rise of leasing, and again, Article 83 bis has supported that. We've seen states act as guarantors, and I always like to talk to the students about the emissions trading scheme of the EU and how some states were, of course, didn't want to participate in this scheme and were then threatening to revoke their state guarantees for orders of Airbus aircraft, for instance. And so, of course, this impacts greatly at the risk of a trade war. It impacts greatly on the European economy, let's say. Of course, I take this from a bit of a European perspective as I'm sitting in Europe. But then we also have, of course, the US export facility, which gives some tax reductions, tax benefits, which we know has been the case for Japan, which is quite involved in that. So just to say, in terms of disputes, we've the age-old, 17 years or something, dispute between Airbus and Boeing, the longest standing dispute from both sides at the WTO. And it's interesting, first of all, just to note the number. I think it's $3.3 billion was paid by EU and US businesses in duties, imposed by each side. And it's interesting and good, I think, to note that the two sides have laid down their boxing gloves last year and put a sort of a truce on it, dropped all tariffs for a period of 5 years. Now that can also change with the political winds, but it's nice to see that they have dropped that to enable state investment, and really with a view to focusing on the rise of the third party here, which is COMAC. And so it's you may be aware, but if you're not, you should be aware that there's a joint committee that is working together, the EU and the US and their respective trade representatives, thinking about ways to, cooperate and deal with a kind of a fair competition drive, which is, targeting the non-market actor, which is COMAC. We also have contractual disputes. We've seen a huge dispute between Qatar Airways and Airbus. So that's another big issue, which I think impacts on the finance. We've had lots of disruptors, financial crises, COVID, war now, the environment, and also the rise of the conscious traveler. So there are also external sort of impacts on the aviation industry as a whole, which I think trickle down or up into aircraft finance. If you could go to the next slide, please. Right, so what I wanted to talk to you about today is a state aid, but in a new dimension. So state aid has within Europe has really developed over time. There was a when I studied state aid law, it was illegal except for some minor exceptions, and those exceptions, any state aid paid to any undertaking, public, private, should be a one-time, last-time injection of capital. And this has evolved greatly to include rescue and restructuring aid for failing companies that have a prospect of success with state aid. And also then the 2014 aviation guidelines, which are specific state aid rules relating to airlines and airports. But we have a new thing coming on the back of, which is here, on the back of the environmental objectives which Europe hopes to achieve. And I think this plays a role, certainly will have an impact on aircraft financing and going forward. So it's all based on the 2030 climate and energy framework of the European Union, where the European Commission has proposed, and it's been accepted, to reduce greenhouse gas emissions to at least 55% compared to a baseline year of 1990. This is a hugely ambitious goal. But with that goal comes some money to invest, state money, public money, to invest in various projects. So we have a European Green Deal, which you may have heard about. If not, I'm sure these slides will be circulated. You can click on the link and read more about it. But it's interesting to see how the green objectives have found their way into the EU competition rules, or rather how member states of the EU are using the environment as a one of the criterion for assessing or enforcing competition law. And this also comes across to state aid, which I'll come on to in a moment. Now, the driver for state aid is really the obligations put on the member states of the European Union and its institutions under the climate law, which is new, well, sort of new from last summer. And it sets legally binding target of net zero greenhouse gas emissions, as I mentioned, and it binds the member states and the national level and the institutions to achieve this effectively. So it is this point of moving towards a climate neutral economy, the first ever, Ursula von der Leyen always says, the first climate neutral continent. And all of this is with a view to achieving the Union and the member states' Paris Agreement commitments under the UN Framework Convention on Climate Change. Next slide. So the key policy and law in this area, I mentioned the Green Deal, which is really a policy agenda. There are lots of proposals. There are different policy instruments required. We have a legislative package, which you might have heard about, Fit for 55, which is this 55%. There are all sorts of things there, but you can see green transition and transformation, growth strategy, and so on. This is also part of the manufacturing sector for aircraft. But that comes across to with the Paris Agreement requirements, obligations, the European climate law, which I mentioned. We have the European emissions trading system, which I mentioned at the start. But really the key thing is to look at the new horizontal guidelines, so horizontal cooperation. And there is now a sustainability chapter in that. So we may see cooperation between firms at the same level of supply, legal cooperation or lawful cooperation. We also have new state aid guidelines, which I'll come on to in a moment. And a very unpopular thing with airlines, which I think will change really, or really shake up the industry. And this is a whole nother talk, but the proposed revision of the Energy Taxation Directive, where we are quite likely to see minimum tax on kerosene, including aircraft kerosene. Next slide, please. Right, so the European climate law, which I've already mentioned, I think there's not much to say there except that it will give way to investment. So if the states are required to meet these objectives, then they must also put money where their mouth is, if you like, to ensure that firms operating based and operating within the European Union are then achieving these objectives. So a great amount of investment will be required. And I think that in the current environment, which is a little investment adverse, shall I say, the state, of course, will be play a key role here. Next slide, please. Okay, so the really focus of what I wanted to talk to you about today are the guidelines on state aid for climate, environmental protection, and energy. These are new guidelines which complement the existing aviation guidelines from 2014, which I mentioned earlier. And I just picked out a few key provisions. It's a very long document, but I've just picked out a few key provisions here. Of course, one big thing is the sort of categories of aid, which may be legal aid. So aid for acquisition and leasing of clean vehicles and clean mobile service equipment, and for retrofitting of vehicles and mobile service equipment. You can see aid for improvement of energy and environmental performance of buildings. Okay, that's more relevant for airports, of course, but also aid for energy infrastructure. And I have thought a little bit about the implications for airlines as the big customer for aircraft manufacturers. And what this will target really is the clean vehicles. And what do we mean by clean vehicles? Well, aircraft with zero direct emissions. So if we just pause there for a minute and think about aircraft with zero direct emissions, this is a huge ambition, of course, but the required financial investment in such research and development is enormous, and will need to be not only from private actors, but also from state actors. So this scheme or the guidelines facilitate such development, green transition in aircraft manufacturing, design and manufacturing. We also have aircraft with substantially improved environmental performance as compared to aircraft of the same takeoff mass corresponding to, anyway, there's a long phrase there. This is taken from the guidelines. Acquisition of clean mobile service equipment, such as electrical ground power units. I mentioned retrofitting, refitting, adapting vehicles to make them clean vehicles. So the point here is that if there is environmental aid, and I have been going around to various airlines saying, listen, I know that state aid has been a kind of a dirty word for a long time in our sector, but now there's an opportunity to ask for state aid, and for that state aid to be, should a state be willing to give it in the first place, that's of course a key point. Does the Kingdom of the Netherlands have, and are they willing to give the money to the likes of KLM or other operators in order to change out their fleet and so on? That's a big question, and that will vary between member state to member state, which again in itself causes a bit of an issue of fair competition within the European Union. But anyway, the point is that there will be certainly some customers who are supported by their respective states where they are based to invest in new types of aircraft or to change existing types of aircraft. So there's really a new market emerging there, I think, that is, again, not only a private investment market, but where the state will play a big role. If it's non-environmental aid, then we fall back to the aviation guidelines, which are more restrictive. And of course, we've seen other examples of state aid during COVID, and now with the repower, the power. I mean, there are ordinary occurrences that have come up. But for some airlines, actually, one good example is COVID was difficult for Finnair, the Finnish flag carrier, but actually the current crisis in Ukraine war in Ukraine is a bigger problem for Finnair because of its geographic location and its business model. So there are, should we say, there's quite a bit of flexibility in the state aid regime for exceptional emergency situations, and we've seen the response of the European Commission and the member states to keep things going for airlines. I have a bit of an issue because, of course, the same aid has not been provided to airports and certainly not to ground handlers, which have got very little state aid throughout this pandemic. Anyway, but this, I hope, if you go to the next slide, please. I hope slightly different message, but if we come back, I also do not make use of autonomy, the free and integrated, liberalized sector, co-op, and if we don't, we run the risk of returning to a greater level of state intervention. That's a general statement, but of course, state intervention, state involvement, even state interference in a market such as aircraft design and manufacture is perhaps needful. And so I think a balancing act is required. I don't have answers for you necessarily, but I hope this gives you a bit of an insight into how things are progressing within the Union, the European Union, and how the kind of new phase, should we say, of cooperation between the EU and the US, Airbus and Boeing, is perhaps also changing things quite a bit. Next slide, please. Well, thank you very much. You've got my email address if there should be any questions, and you've got the website of our institute, the International Institute of Air and Space Law at Leiden University. I will not be able to stay until the very end, so because I've got a flight to catch, but thank you for this opportunity. I hope this is helpful to you. I wish you a really successful conference today. And as Hamza has said just before me, as an academic conference, we have a duty to ask the difficult and uncomfortable questions, to challenge them. And I'm very happy to support you, Professor Sandeep, the other centers around the world who are working very hard to develop the young minds in the areas of air and also space law, because I think it's really needful. Thank you.
Thank you, sir, for your talk and really shedding the light on the role of the state in the market and sort of showcasing the present and future of attracting investment, and also giving your perspective of the European perspective, which, you know, here in India, maybe we might not really have. And also the special focus that you put on the 2014 guidelines as well as the CEAG 2022 guidelines. And also, really, lastly, the challenges of affording green vehicles and how we can really make sure the state aid, how we can ensure that it works in our sort of quest to go greener. So thank you very much. And I now hand over the mic to Barsha.
Good morning, everyone. I hope I'm audible. Am I audible? Okay. Okay, so I would like to thank our Honorable Vice Chancellor, sir. In spite of his extremely busy schedule, he has provided us his valuable time and his guidance and his support. I would further like to thank the Director of the Center for Aviation and Space Law, the West Bengal National University of Juridical Sciences, Professor Dr. Sandeepa Bhatt, sir, for organizing such a wonderful event for us. And most importantly, our most valued guests for today's inaugural session, Professor Hamid and Professor Truxell, for their wonderful speech and for giving us an insight about some of the most important issues related to aviation financing. Now, Ayashri will be hosting the remaining portion of this seminar, the technical session 1. So, Ayashri, over to you.
Thank you very much. We will now begin with the first technical session. We have with us 4 speakers for the session. There will be a Q&A session at the end of the presentations, and participants are to post their questions in the chat box. So without further ado, we will begin.
Truxell and Hamza, thank you so much. Actually, thank you so much for your participation and also your cooperation throughout. Thank you. I know that both of you have a flight to catch, actually, so that's why I have to thank you right now. Thank you. Ayashri, go ahead.
Yes, sir. Thank you. So, yes, so without further ado, we'll begin with our first speaker. So our first speaker for this session would be Dr. Attila Sipos. Dr. Sipos is currently a faculty member at the Air and Space Law Center of Sharjah University. He's a Bar Association advisor at the Aviation Division of HMLCO. He's also an honorary professor at the AJAK. He served at the Hungaro Control in various positions, including as legal director, alliance director, and advisor to the CEO. He was the representative of Hungary on the Council of the ICAO and the vice president of the Council of the ICAO. He had worked at the Malev Hungarian Airlines as flight operation officer, crew manager, legal advisor, and legal director. He has also been a committee member of the European Air Law Association since 2004. I now request Dr. Attila Sipos to give the presentation on the topic of dealing with jurisdiction and applicable laws in aviation financing. Over to you, sir.
Thank you very much, these wonderful words and kind introduction. You are all welcome. I'm very happy to be again with the team organized by Professor Sandeep. Today I'm shocked, many things, new information I received. We have a new ambassador, Professor Sandeepa, who is the correspondent of UNIDROIT. Okay, we have, I listen in Hamza Said, email address is Hamza Said, Hamza Hamid 007. And there are plenty of things happening with me. I am very proud India is a contracting state of UNIDROIT of the Cape Town Convention, and so plenty of things. And I'm very grateful to be here and to share my view regarding of aircraft financing and jurisdiction applicable law. Professor Sandeep nearly explained everything, so I have not much to do, but I would like to go into a little bit into the practical things, because I was so lucky to, as I used to work for the airline industry, and I was involved to buy new aircraft from Boeing and Airbus, and also I was in the military, and we bought many helicopters and airplanes. So I was witnessed a lot of cross-border financing. We prepared a lot of contracts, and of course we were sometimes in default. But honestly, when we work on the project, we always focus in the contractual relations. We look at always the warranties, the patent indemnities, the contractual issues like exclusivity, the delay, the purchase price. A lot of things we focus, but we never focus honestly about the governing law and the jurisdiction. Because the governing law jurisdiction, in our perspectives, it's mainly for taxation, VAT, financial issues, and we thought there will be any dispute. There will be no dispute between the lessor and lessee, the buyer and the seller, or the creditor or the debtor, or the lessee or the lessor. So we always believe there will be no issue, and the governing law, I mean the jurisdiction, will be not the issue when we have to think about this one. But sometimes happening, as mentioned Professor Sandeep, there are defaults are coming quite often. And if there is default and there is no mutual consent, there is no mutual agreement between the parties who are involving into this contract, of course they have to go to the court or to the arbitration, and which really open the issue about jurisdiction and applicable law. Okay, I have sent my presentation. Somebody can upload it, or I have to upload it, or oh yes, that is all right. Superb. It was just my introduction. Please, I ask him kindly, if I am run out of the 15 minutes, just kindly warming me, because this topic is, I like this aircraft financing, and we have a course, aircraft financing and leasing, here in Sharjah University, and we're focusing much over this issue. All right, please go to the second and the next slide. Okay, the definition. As I told you, applicable law and jurisdiction is not our agenda every day. Our agenda is mainly the purchase related issue, the manufacturer support, what is happening in the default, or the registration. The registration issue is in our mind as a lawyers, the legal persons. So that's why I have defined a jurisdiction applicable law. Aviation is a conservative industry, so I'm not using Google. I'm using a small dictionary always with me, and that shows what is jurisdiction and applicable law. I think very clearly. Okay, so they are talking two different things. That's why I wanted to highlight for our distinguished colleagues, distinguished audience. Okay, so next slide, please. And if you look at these two definitions, I was thinking a little bit. I was just playing in my mind. I was playing in my mind. How can we put into the context in Chicago Convention, Tokyo Convention, Montreal Convention, and of course the Cape Town Convention as well, because these are crucially important. So if you look at the Chicago Convention, Tokyo, Montreal, just as an example, it is not part of my presentation, but really how important the jurisdiction and how important the applicability, and then is applicable under what circumstances. So these are crucially important as a lawyer or the legal student or advisor to understand the differences between these two legal terms, and also the meaning. So you can find those in all treaties, and please, I encourage you to find all of them. Next one, please. It was just an example. And now I am in the presentation, in the middle of the presentation. Thank you very much. Okay, aircraft definition. We have to talk about the aircraft because, of course, that we have a parties, lender. I mean, we, of course, sometimes lender, but lessor and lessee, and what they are focusing on. Of course, they are focusing on the business. They want to make money. Everybody wants to make money, of course. How? Of course, in operational leasing or financial leasing or different kind of structure, they using the aircraft. Aircraft has a meaning, not only as a meaning as a definition in Chicago Convention Annex 6, 7, 8, but also as aircraft we have to define as a financial perspective. Aircraft is a movable chattel, is a very expensive tool. Truxar said how expensive. It's very expensive tools, which including those things which I mentioned on the slide, and it has a personal property with nationality. With nationality is important things and comes into our mind, of course, the Chicago Convention Article 17, which said the aircraft has a nationality of the state which they are registered. We all know this register issue. If the aircraft is registered in India, of course, it is a quasi-territorial jurisdiction, which means the Indian law will be applicable, or Indian jurisdiction will be applicable on board of the aircraft. So the Indian law is important, but it not means it's a territorial jurisdiction. I said it's quasi-territorial jurisdiction. So this is the major principle in this regarding of jurisdiction, because the nationality is determined the place of the registration and not determined by nationality of the aircraft owner and the operator. So the registration is crucially important, and it has a lot of legal effect, which we have to be aware. Thank you. Next one. These are just mentioning few things. This registration must be transparent as well, and must be single and valid, because it has a lot of consequences. As I said, flag of convenience is not so popular in our industry, in aviation industry, because of the technical issues, because of the surveillance issue. But we definitely have, not as much like in the maritime industry, but we are facing on this issue. And for that reason, the registration, which is one of the most important jurisdiction, principle of jurisdiction, or forum of jurisdiction, must be carefully followed by the national rules and also followed by the ICAO and its annexes regarding this issue. Next slide. I said that there are a lot of critical issues regarding of jurisdiction, applicable laws. Of course, when we make the contract, we have to face always the contractual issues, rights of obligation of the parties, what are the propriety except the validity of the right, whether is the right valid, and those kind of issues. Legal issues, of course, jurisdiction mainly is the state, for instance, contracting state of the Cape Town Convention or not. If not, the local laws will help. They support the informants of the legal rights, which was, different kind of rights like reams, hypothec or mortgage, and the lien. So there are plenty of things. So that kind of things, political risk, are very on board. Look at the situation now in Russia and the other part of the world. And there are plenty of risks we have to face with, and we have to take into account when we're talking about jurisdiction and applicable law. Okay, first, next slide, please. And now we look at the jurisdiction, look at the applicable law. I summarized the major jurisdictions. There are plenty. Luckily, we have lots, and if you look at the Cape Town Convention, it provides us many jurisdictions, and lawyers or legal advisors or jurists are very welcome if there are plenty of jurisdiction. Look at the lex situs, the law of the place where the aircraft was located at the relevant time. It was mentioned in the lex for and lex loci in the presentation of Professor Sandeep, and also the lex domicili, which is the law of the place of the owner of the aircraft, lex actus, Lex Registry. Lex Registry I don't have to introduce because we have just discussed as a registration part of the previous slide. Okay, an applicable law. Of course, the applicable law, first of all, the parties can decide, they can choose which law will be applicable. That they have a freedom, definitely they have a freedom to choose. It is limited many ways. If you look at the convention of, for instance, Geneva Convention, for instance, it is limited in the regarding of that if there are some public interest which has to be safeguarded by the states. It means there are provisions which allow overriding the mandatory provisions under special circumstances, and that happened in China, and it happened also in Canada. So that is also possible. Freedom is not absolute freedom regarding this, but of course is a freedom because that is a contractual relationship, and this is one of the essential principle of the contractual relations and the relations of the party. If the party have not chosen, of course, the contract can be governed by the law of the country, which is most likely connected. All right. Of course, just to avoid the problem in the practice, when the lessor and the lessee make the agreement, the lessor sent a legal questionnaire, a jurisdictional questionnaires regarding this issue, asking a lot of things, which law is applicable, under what circumstances, and many issues will be clarified before the contract will be signed and they decided which law will be applicable. Thank you. Next slide. Yes, it was mentioned Boeing and Airbus. If I was really lucky to involve few contracts regarding them. Of course, as I said, it's a free choice regarding the jurisdiction, regarding the applicable law. But the Boeing, when you purchase a new aircraft, they insist to have the applicable law in Washington State, Washington, in Seattle, because they have they have the manufacturing in Seattle, so they insist to have the U.S. and the state of Washington law. In Airbus, they are not insisted. They are very flexible regarding this. But if you look at the Airbus and the Boeing contract is a little bit flexible, but not flexible regarding of the governing law. But the Airbus contract is a full with provisions, full with requirements, obligations, tons of them, but they are not as strict regarding the governing law. Most commonly, aircraft operating lease is governed by the English or New York law, and because of the reason is very simple, they have well developed commercial legal precedents of those jurisdictions. What are the legal sources for us? What are the legal sources? Because we talk about the jurisdiction. Of course, the Rome Convention. Rome Convention is under-ratified, but still in force. It's very important to know. The Convention for the Unification of Certain Rules relating to the precautionary arrest of the aircraft. So they are in force, but not as important because the Cape Town Convention will supersede this treaty. But then we have four other things we have, which is the source, the Geneva Convention, which is all of you are known, and there are 91 states, more member states than Cape Town Convention. Although we have heard it will be 84 in the future, in the near future, and congratulations for that development. But of course, the Geneva Convention, they are in terms of jurisdiction, they are focusing, if you look at the Article 1, Para 1, for the Lex Registry. There are a number of exemptions regarding this in the convention, but they are mostly focusing for the Lex Registry where the aircraft was registered. There are a few exemptions because of if you look at the convention, it is only relates to the recognition of the rights of the aircraft and not consider the aircraft engine separately, because the aircraft engine is stipulated as a component parts of the aircraft. And that kind of component parts, when they are going to sell and buy, that is out of the convention. So it can be the place of the sale jurisdiction. So the Cape Town Convention is very welcome. There are plenty of jurisdiction. The parties has freedom to find the jurisdiction, irrespective whether or not the chosen forum has any connections with the parties. And also the lawmakers allow for the parties to use where the aircraft is situated, where the aircraft is registered, where the debtor is situated. So there are plenty of choice regarding of jurisdiction according to the Cape Town Convention and its protocol, aircraft equipment protocol. I mentioned here the Rome 1 regulation and Rome 2 regulations. I have to mention it also. It is apply for the European. It is the regulation of the European Union and apply for the European carriers, community carriers. But that is the Rome 1 and Rome 2 Convention as a universal acceptance as well, or application as well. So can be applied in the context and the contractual relation for those states who are not a member of the European Union. Of course, the law here, and if you look at the Rome 1, it can be chosen by the party, definitely, and the contract shall be governed by the law of the country where the party required to effect the characteristics performance of the contract has his habitual residence. So the residence base is also possibly provided by the lawmaker or the regulatory maker to the parties as well. If the parties are not determining of the jurisdiction, of course, by the law of the country with the most likely connected, which was mentioned in the previous slides as well. Next, please. So we have a lot of jurisdictions, and I don't feel there is a problem or applicable law for the parties, although the problem is arising mostly with the sources, because the Geneva Convention is mainly based on civil law system, and Cape Town Convention based on common law system. It is not a big problem, but that's why if you look at the ratifications, there are still plenty of states ratified the Geneva Convention, and also now more and more the Cape Town Convention. And also can be a problem, and don't forget in the practice, maybe the Cape Town Convention is ratified, but not enforced. There are states which has double system, which means when the states ratify the convention, it will take into force later, maybe 1 or 2 years later, after the procedure, parliamentary or the other procedure, judicial procedure of the state. So when you ratify the convention, it's not automatically take into force or come into force in the state. It sometimes takes time. So we have to pay attention for this issue as well. But the very important is the Geneva Convention only relates of the recognition of the rights of the aircraft and not provide a clear conflict of rules. And that kind of missing we can feel from the Cape Town Convention as well, although provide a lot of jurisdiction and provide a lot of solution, but still the clear conflict of law rules are missing from Cape Town Convention as well. For that reason, my conclusion is the jurisdiction still remains paramount important issue. That's why many arbitration dispute resolution, alternative dispute resolution are very welcomed and getting more popular in the industry. So we are still facing with the national rules, national regulation in the future, which is I don't feel is a problem, but it is not supporting the unification of the certain rules regarding of the aircraft financing in the world. Thank you very much for your attention, and I am very happy or glad to share my knowledge with you. Thank you very much.
Thank you, sir, for your presentation. The in your presentation, I think we've all really understood and gained a lot about the nature of the jurisdictions, the various jurisdictions that exist, the critical issues that we face, and the risks that need to be taken into account at the same time, and also the different governing laws that are there and the application of those laws, and as well as looking at the other side, the course that usually aircraft manufacturers take. And lastly, the focus that you put on the Cape Town Convention and your recommendations to it. So thank you very much for that presentation.
Okay. Is it possible to make some comments, some kind of discussion between the presenters, or is that not possible?
So we have kept that for till to the end of the session. So there will be.
Yeah, but at the end, is it not for the other people, not for the presenters? So I'm talking about a discussion between presenters, not questions of others that are listening to the presenters who need to write down their. I'm talking about a discussion between us.
So I think that we definitely, it would be enriching.
But you won't have time. You won't have time later. Very simple. You won't have time. And I'm not going to write down the questions which I have for Attila. I know Attila for don't know how many years. Attila, great to see you. You used to be my student, International Aviation Financing and Leasing Law. But I have something to discuss with him, which is extremely important. And if it is later, you won't have time for the other people's attending, not presenters, to ask their questions. Or this is a dispute between Attila and I. This is a dispute between Attila and I. It's not a question. It's comments, my comments to his presentation.
Dr. Attila, you're on mute now, actually. So can you unmute yourself?
I am unmuted?
Yeah, you are unmuted. You are unmuted. So would you like to actually make a comment right now, or we have time actually, because actually there is one presenter who is not there now.
Comments.
Okay, go ahead with that.
Comments. It was very quick. Attila, great to see you. Wonderful. First of all, choice of law. Okay, you say New York popular, England popular.
Yes.
But no, it has a limited effect.
Of course.
It has much effect. Because using the law of any country, including New York or England, is totally limited. Look at the Blue Sky Mahan Air Case 2010. It only regards the contractual aspects between the parties, no third parties. So it does not cover a chosen law, English. Look at Blue Sky. It does not cover the validity, effects, enforceability of a lease agreement or any other agreement. And that has been confirmed in Article 8 of the protocol, Article 8. So it is limited. Any choice English law is limited. I hope that is clear to the people listening. It is not total. Okay, one thing. Secondly, Geneva Convention. It is not in my book really a civil law treaty at all. It is influenced by the United States, which is a common law. In 1948, the continental European countries and their old colonies in those days, colonial times, they had no aviation finance law at all. Nothing. They could not even create a mortgage on an aircraft. It was impossible. Other rights which are covered by Geneva Convention are all influenced by the United States. So saying that the United States is a US treaty, common law, nonsense. It is, it is a civil law treaty, that's what you said. I don't believe that. I do not agree with you at all. It is a common law in the sense it is a US influence treaty because we didn't have the recognizable rights in Europe and their colonies. We didn't. Thirdly, and then I stop because it's enough. Sorry, Attila. Thirdly, the lex registry, the lex of the CITES. Okay, that is what allegedly Geneva would say. Applicable is the law of the state of registration. America opposed to that in 1948 in Geneva already. And why? Because in like the United States, Canada, and even the tiny Netherlands, in federations, if that would be right, it would refer to, for example, the United States. But the United States, okay, has no federal mortgage law, property law, any aviation, finance, or lease law. It is not federal. So which law are you going to apply if the law refers to United Kingdom? To the United Kingdom, you want to have English law, you say. But English law is not UK law, it is not federal law, and you don't want to apply Scottish law. Same in the US, you don't want to apply the law of Nebraska with all you want New York. So the Lex Registry, what you say is contained in the Geneva Convention, doesn't work. And therefore, it is not the Lex Registry, it is the Lex of the state, but then including renvoi to get to some other state where you want to be, and that is not Nebraska or Oklahoma, where the FAA is located. That is where you register at the FAA in Oklahoma. I hope I made my point.
Mm-hmm. That is fantastic.
Otherwise, people may. I want to clarify this.
Yeah, I want to clarify as well few things. Okay, thank you very much, Patrick. And you have much experience in the United States because you are teaching, you are living there as well. So, of course.
Hello, Amsterdam here.
Okay. Now, three things. You mentioned three things basically. And first of all, what I said, the operational leasing. So, operational leasing, not financial, the operational leasing majorly is under the law of the English or New York or Quebec or California law. Sure. Operational leasing. So I'm not talking about the purchasing of the brand new aircraft, selling of the used aircraft, and that kind of other contractual relations. I just mentioned the operational, which is very popular. That is the most popular attraction, contractual relation in the world, because air carriers cannot afford to buy new aircraft. It was mentioned by Professor Sandeep in the morning. So first of all, that was mentioned. And the second thing, the Geneva Convention is not a civil. It has a lot of civil law related matters. That's why my country, for instance, not ratified Cape Town Convention and still in the Geneva Convention, because we are a civil law country. And we found more familiarity with the civil law. Yes, there are common law influence as well, but it's more civil than common law according to our legal system. Certainly, you mentioned this UK or England, that kind of circles. When we made the business with the ILFC, the International Lease Finance Corporation in California, yes. in Los Angeles, I was the head of the delegation. Many times I went to Los Angeles in my life, and we, at the end, the law was, Californian law was the applicable law in the contract. They were insisted for that. That was my experience regarding this.
Yes, but make a distinction between proprietary aspects of a contract, validity, enforcement, and that is most important in aircraft financing. It is not the contractual aspects which are in aircraft financing, leasing laws are most important. Right. It is the other part. It is the proprietary part. It is my mortgage valid? Is my title valid? That is not governed by the chosen law. See Blue Sky case 2010. And that is where England said it, an English judge said it himself about English aircraft, English mortgage. The law chose an English law for the English mortgage, validity enforcement. The court said, no, I'm not going to apply the law of my own country because that's not how we do it.
Mm. Sorry. No, I'm happy. Good. I'm waiting for this time in my life.
All right. Thank you, everybody.
Thank you for igniting the debate, actually. So, yeah, anyhow, Isari, we can carry forward. So there are, I think, 2 more presentations. We have still some time available, actually, since there is one presenter who would not be.
Yeah, we need a bit of a stir once in a while to keep the people listening busy and.
Yes, I see.
Thank
Otherwise,
you.
great, Attila. Otherwise, great presentation. Fantastic. Thank you.
You are fantastic, Patrick. You are.
So our next presenter, our second speaker for the day, would be Professor Anna Masuti, but unfortunately, due to certain contingency, she is not here today, but she does extend her best wishes for this conference. So we shall move on to the third speaker. So our third speaker would be Mr. Aditya Varayat, who is the Assistant Professor and Coordinator for the Center for Research in Air and Space Law, Maharashtra National Law University, Mumbai. He's a member of the Information Society Law Center at the University of Milan. He has co-authored a book titled An Introduction to International Law, and he was also a research group member for the Center for AI and Digital Policy in Washington, USA. I now request Mr. Aditya Varayat to give the presentation on the topic of aircraft leasing contracts and force majeure reevaluating UNIDROIT principles of international commercial contracts in a post-pandemic era. Over to you, sir.
Thank you, Aisri. Am I audible to all of you?
Yes, sir, you are.
Yes, thank you. Thank you so much. So before I start, I'd like to extend my gratitude to Professor Sandeep Bhatt, sir, and the center for inviting me to this conference. I have been a great beneficiary of the center as well as Professor Bhatt. He's a father-like figure for me who has been mentoring not just me, but also the center. And I'm extremely thankful to you for having me. So the topic that I'll be speaking on is aircraft leasing contracts and force majeure and reevaluating UNIDROIT principles of international commercial contracts in a post-pandemic era. And the whole idea of talking about this particular theme is to see how this debate of force majeure and how it has been implemented in the context of leasing contracts. So if you look at the whole debate of force majeure, you'll see that while air passengers are booming, the sector itself is facing towards some form of crisis. This is what I'm trying to argue. And my core argument for this presentation is the idea that the real story of civil aviation is in its footnotes and not in the headlines. Because you see, even in India, you will see that this whole issue can be contextualized in terms of how, because of aviation fuel rises, the depreciating value of rupee or competitive ticket pricing, due to all these factors, airline in India is not earning profits. And these losses actually run to crores. And globally, these problems have intensified with the outbreak of COVID-19. And it is certainly will have a long-term impact on the impact of aviation industry. While we have to think about restructuring the models of aviation governance and focus on rebuilding the industry, we have to move towards a form of maybe a contract form wherein you focus more on revenue generation. In this context, the Cape Town Convention, along with its protocols, have indicated a significant development of the airline industry. So there has been an exponential growth in this commercial aviation industry over the past years. But as Professor Bhatt said in his opening remark, that this industry is very capital intensive. And because of it being a very capitalist intensive, you will see that airlines acquire more aircraft in the form of leasing. And leasing provides airlines with several economic advantages as well. So the Cape Town Convention, that's the point of discussion for today's talk, focuses on defining what exactly is a lease. So according to the Cape Town Convention, you will see that a lease is an agreement by which one person grants a right of possession or control of an object to another in return for a rental or other payment. So, however, with the outbreak of COVID-19, the global lockdowns and international border controls that happened, it has hampered the financial position of airline companies. And it is actually forcing the companies to reassess their obligation towards leasing contracts. So most of the contracts that we talk about provide a provision for force majeure remedy, which allows the parties to excuse their liability for non-performance due to maybe some unforeseen event. So you will see that majority of the airlines acquire their aircrafts through leases that do not excuse payment based on what we call as the hell or high water clause. Therefore, irrespective of any event, airline operators must fulfill their obligations by paying for or taking delivery of an agreed aircraft. So, however, due to the pandemic, airlines are in a state of perplexion regarding their position as to fulfillment of these absolute obligations that we talk about. Now, this nature of absolute contractual obligations under these contracts, specifically regarding performance, mostly remains the same irrespective of the type of lease. So international air law has attempted to actually harmonize and standardize a legal regime that can act as an authority to determine the nature of these contracts and guide the global aviation industry, which can conduct this cross-border business. So, but what has happened after the proclamation of WHO that COVID-19 is a pandemic? The aviation industry actually reported more than 70% drop in the global air traffic. Now, despite these losses, airlines still have an additional cost and various other fixed charges that cannot be avoided. For example, like maintaining the airworthiness of vessels, etc., etc. Now, these expenses add a significant revenue burden for the airlines, as they do not have the resources to actually pay for these things. So, many of the airlines have went to restructuring their recruitments, trying to negotiate on airport parking services and other mechanisms. But this whole debate has made it very clear that pandemic has caused a major financial difficulty for airlines, and taking measures such as delaying of lease payments have negatively impacted the relation between airlines and their lessors. Now, it is important to reevaluate these contractual obligations in the light of damage caused due to the pandemic. Okay, so in this context, due to financial losses that are suffered by the airline industries are looking forward how to revive and survive and avoid liability for the default of their leases. Now, one such idea that has come out is the using of this doctrine that we call as force majeure to circumvent the lease payments. However, you will see that because of these lease agreements having something called as the hell or high water clauses, it is questionable whether airlines can invoke force majeure to excuse their performance, considering the issue that we are talking about is a pandemic. Now, aircraft leasing agreements and the probability of the contract processing a force majeure clause is very less. However, this clause is present. Its scope and application, we have to actually look into this idea that can force majeure clause also be interpreted to mean something like a pandemic. Now, you will see that in 2005, when the China International Economic Trade Arbitration Commission they failed to consider SARS as an outbreak having a force majeure value. And it did during the outbreak of SARS, they did not allow parties to excuse themselves from non-performance under this clause that we call as force majeure. Now, majority opinion appears to be that unless there is a specific mention of epidemic or a pandemic in the force majeure clause, the pandemic will not be applicable. Now, the SARS outbreak is very different from the COVID outbreak that we just witnessed over the past few years. Now, as a response to this outbreak, many nations have tried to provide economic relief. Various national governments, various institutions are trying to propose some form of certificates to consider pandemic a force majeure occurrence. Now, which is a major relief for many of these airline industries. For example, the same Chinese council that delivered the decision in 2005 has recently issued around 1,600 certificates, saying that force majeure can be considered, can also include something like a pandemic. Now, it is not just China that did it. Various other countries also followed the same practice. Now, the problem with these certificates is that these certificates actually have maybe a symbolic idea or a symbolic identification of pandemic. The legal consequences of these certificates is still to be decided by a lot of jurisdictions, especially in international forums. Now, it is a very well accepted principle of law that contract must be read as a whole, and courts have applied this principle while rejecting force majeure remedy as well. For example, the Olympic Airlines case or the Electric Capital Corporation case. You will see that in a lot of cases, the hell or high clause was absolutely binding lease. So even after the leaser failed to provide an aircraft in airworthy condition. Now, force majeure is clearly not a possible solution in this context. This is what I'm trying to put forward. But also, I argue on this idea something that we call as the hardship doctrine. Okay, so this is an idea that actually comes up before when we talk about hell or high water clause, that because of the spirit of these agreements are to ensure performance, even if there is a contractual provision or a government measure allowing application of force majeure, the contractual provision or government measure will likely be inapplicable. So, however, considering the hardship doctrine, we can talk about COVID-19 pandemic being classified as a hardship event in the airline industry. So, the COVID-19 has given this message that we'll have to rethink about the force majeure doctrine that we talk about. And UNIDROIT has been focusing many of its attempt to consider this idea of hardship and force majeure as hot issues in its discussions. For example, the lack of uniformity of domestic rules in the issue of force majeure. The problems that we talk about in UNIDROIT principles of international commercial contracts. But in these situations, applying hardship doctrine to aircraft leasing agreements, I argue is a viable option. If not a viable option, it's a better option as compared to the force majeure doctrine. So the doctrine of hardship can also help to circumvent the hell or high water clause because it is based on the principle of ensuring payment by renegotiation, thereby upholding absolute contractual obligations and ensuring financial security for the lessor. On the other hand, we talk about this idea that the idea of force majeure, it can be renegotiated. There has to be particular attention to list out maybe a non-exhaustive events that can be included as a part of force majeure clauses. So there are arguments from scholars who argue that if a long list of force majeure events are included, it is likely to be more helpful. If a specific wording is included, like a pandemic or an epidemic or maybe an outbreak, can be a better solution to this. But on the other hand, you will also see arguments like counterparty negotiations of contracts may be affected, or there should be renegotiation in terms of how contracts are made. But this actually calls for this idea that we will have to rethink how the aircraft and the airline industry will talk about these issues in the future, because this crisis cannot be seen as a one-timer crisis. And unless there is codification or harmonization of laws, the next time something happens, this event, you will see a repetition of these events. So in my working paper that I'm working on, I'm talking about how can the idea of force majeure can be replaced with something like a hardship doctrine, or a better idea could be maybe, as scholars argue, regarding how there could be an exhaustive list of force majeure events. So considering the paucity of time, I'll end here and I'll reserve some time for the questions. Thank you so much. Thank you.
Thank you, sir, for your presentation, and really sort of beginning with looking at the current scenario that's there and calling for a sort of restructure in the aviation governance and maybe forming newer models where we have revenue generation as a focus area, and then really looking at giving a very good viewpoint of how we construct force majeure, whether we can bring about changes to that, and lastly looking at alternatives in the form of the hardship doctrine. So thank you very much for that.
Actually, you are muted.
You are muted. Yes.
Apologies for that. Apologies for that. Forgive me if... Hello, am I audible?
Yes, I see. Go ahead.
Okay, so I think we'll be going to our last speaker for the day, who will be Ms. Dhruvi Agarwal from the Hidayatullah National Law University, Raipur, and she will be presenting on the topic of concerns in aviation financing related to adoption of green technologies. Apologies for the delay. I think maybe there is a sort of technical problem from the side of the participant. Thank you for your patience.
No, more time for questions or not?
Yeah, I think that would be better, I suppose. Right? Is Shreya Agarwal? Is she actually? I mean, is Dhruvi joining as Shreya? Oh, I mean, I'm not very sure. I can't see her name here. Yes.
I
can't hear you. Whether Dhruvi is here? No, Aisri, I think you can go ahead. You can go ahead. If she's not here, then you can go ahead. Or maybe some connectivity issue there.
Okay, sir. So considering that our fourth participant for the day is not here, so I think we'll go ahead to the question and answer session. So now all the participants, if you have any questions, any and all questions are welcome to be put on the chat box and to ask the participants for the first technical session.
Where is the chat box?
So you may, so it's not necessary that you do use the chat box, so you can like ask the question as is.
Are there any questions?
If you have any question, you can ask. You can ask.
May I done? Oh, I see questions. I'll wait.
Okay, so we have a first question by Ravi. Ravi, if you could specifically mention who you would like the question to be directed to, it would be better. Okay, he has kept this question open for all the participants. He asks, how jurisdiction will be determined in the situation of takeover or merger?
Takeover or merger?
Yes, sir.
I think, Attila, that's something typical for you. It is not for me anyway.
Yes, I don't know for you, but merger in the industry is quite difficult. It's not easy. But it happened, the virtual merger, it's happened, of course, in the industry, the KLM Air France merger. That's why I look at you, Patrick. You have to know much more about this. But the merger, yes, it has it is an issue, of course, because when the company merge and they create one, it is a lot of question arising. The air service agreements, the brand, the frequent flyer program. So there are plenty of things are put on the table, and and for that reason is one of the key issue under the merger, how because you cannot make a full merger in the industry, of course. In KLM, Air France merger is a very good example. They keep the brand, they keep their actually operating as one company, but they are two different entities regarding of the air service agreement and these kind of things. And for that reason, is a very complicated issue.
Yes.
So
what I can did I interrupt?
Yeah, please.
Okay. What is complicated in regard to mergers, of course, takeovers, whatever you want to call them, from the point of view of aircraft financing and leasing transactions, which already exist in regard to the company which is taken over, right? One takes over the other or merges with the other, but it is then more of a takeover or whatever. That the existing agreements, the existing finance agreements, the lease agreements, they will have to be very much looked into, restructured possibly. It depends on, is the real takeover, are two companies now airlines one, or is it like, as you call it, Attila, you're right, Air France, which has now the majority stakeholder, the majority stakeholder, shareholder of KLM, Royal Dutch Airlines. But surely, when that happens, the stakeholders of the companies, and certainly the one that is taken over, they want to know exactly what their position is. And right now, under the new structure, they have relationships, let's say, with KLM, which is now a part of, if you wish, a part of Air France. And what are the consequences for these financiers and lessors of KLM? That has to be very much looked into, what their position is. And some will say, no, I don't like it at all, because what is going to happen, that is not in my interest as a major aircraft lessor, major aircraft financier of that fleet of the airline, which is taken over, you see. So there will be a lot discussed in that respect. Maybe the lease agreements will be amended, they will be totally changed with new parties, right? So if we are talking about mergers, acquisitions, takeovers, a lot is happening in regard to the documentary, the transactional world as well. It is not only a corporate problem or issue or matter to attend to, it certainly is a matter to attend to by the stakeholders of the airlines. I hope that is an answer. Is that clear?
And also sorry to interrupt, Trigger, but also in the arbitration is very popular regarding of aircraft financing, and the arbitration is more flexible regarding it if there is the issue. So that can be negotiable, and also the arbitration will choose the jurisdiction if there is the issue, if there is a dispute between the parties, definitely.
Yes, and yeah, I mean, a merger really involves a lot of work of aviation finance lease lawyers. Let me put it that way.
Sure.
Huh? You know it. You know it. It's very important because all the agreements have to change, most likely. And the guarantors who guarantee that the airline which is taken over or is merging, but basically is taken over, those creditors want to know, hey, and rearrange everything. A lot of work. A lot of work.
So thank you to both of you. Ravi actually has a follow-up question to his first question. That is there any difference in the situation if the takeover is done by the government and all things remain same, as in takeover by the private?
Wow. That all is more corporate law than aircraft finance leasing law. But again, yeah, I mean, listen. It depends on what part of the world are we talking about. Are you talking indeed about India? Are you still, or no? I don't think you have any more, since Air India is now also kind of privatized, right? I'm correct, right? Air India, and the others are to a large extent also private airlines. Which countries? Yeah, there are still some countries which have totally 100% state-controlled carriers, the flag carriers. Egypt, for example, Egypt Air. Okay, 100%. But in other jurisdictions, is it not, Attila, like in Europe, state control is a no-no. You cannot control 100% of your airline anymore. I think the last one was TAP Air Portugal, the Portuguese state controlled. They had to, under European law, get rid of the entire airline, or at least 51% privatization. So I'm saying, yeah, the question is, where are we talking about? Are we talking about India? I'm not sure what happens there, to be very honest. I'm not an Indian local lawyer, but state control is not, Attila, something favored in the international arena of aircraft financing leasing. We prefer, is it not, privatized airlines, and most airlines in the world these days have been privatized. And otherwise, I don't know the difference. I don't think that state influence is welcome, because what do governments know about how to run an airline, Attila? You know better than I, because you have been for a long time working for an airline. But state guarantees may help. State financial guarantees in risk states, like India. But in Europe, that is what our colleague Truxell was saying, competition law and everything else. Yeah, that is basically a no-no that the state would control. What do you think, Attila? But it's difficult.
Thank you very much. You know, the academical thinking is always based on the majority. What is majority? You always find the exceptions, which is very, I like it. And the majority, definitely they like much better the government owned issue, because of the, as you, Patrick said, less risk, more guarantee. That was my experience. If the government behind the business, it is much more welcome. And they have more guarantee, banking, financing, and the different kind of guarantee can be granted to the business, and that is my experience. So of course that's the same. I don't feel the same, but the future definitely is privatization, and the more private entity, more private interest and capital in the industry, but they are not treated, that is my experience, in majority in the same way.
Yeah, what does the government know about this business?
It doesn't know about much about the business. The management has to know about the business. The government just as a prestige, as an ambassador. We have now one ambassador. We are as an ambassador of the state, like you said, this flag carrier. And even if British Airways privatized, or Singapore Airlines privatized, but they are still. We don't like the word the flag carriers, but they are, as a national carrier, they are representing the states. So that has a lot of meaning and a lot of power itself. So British Airways is not only an airline; it is UK, not England, UK.
Yeah. Okay. All right. That's it.
Thank you, sir. Now, I would like to ask Shreya Agarwal's question. She would like to ask Professor Aditya Varayat about the incorporation of the hardship doctrine in various jurisdictions. Her question is that while the hardship doctrine is already there in Indian jurisprudence, why didn't the court consider this while the adjudication of cases pertaining to COVID-19?
Okay, so I try to answer the question in the chat box itself. So if you read about the hardship doctrine that I discussed in today's talk, you will see that the Indian court, the Supreme Court, had an option of clarifying this issue, not just regarding force majeure, but also on frustration, also on hardship. And it's a very interesting case, the Energy Watchdog versus Central Electricity Regulatory Authority case, wherein the court, despite having got the best opportunity to clarify this, failed to do it. The court actually said what could be force majeure, but on the idea that can a force majeure situation also be considered as a hardship clause, the court said we are indecisive about it. Okay. And followed by that, there is also a threshold laid down in the Satya Bharta Ghosh case. Similar idea regarding what could be a threshold, what could be considered as a hardship doctrine, but you will see again the court not giving a clear idea or a plain meaning to when it can be classified as something of a frustration or something of a hardship. Now the problem is that despite having this idea in the local jurisprudence, we have failed time and again to actually provide uniformity when it comes to implementing it. And this is not just the case with India, also in the case with countries that have clauses similar to hardship clauses. Now you will see this is the problem that even UNIDROIT is trying to harmonize, that not having, just because you have something in your jurisprudence, but because of not having a uniform practice when it comes to implementation of these doctrines, there is a need to actually revamp the idea of looking at hardship doctrine. And I think COVID-19 has provided the best opportunity for UNIDROIT to actually look into this aspect on regarding when this clause can be made applicable and how it can be made applicable, what should be the thresholds of making this applicable. So if you see, to answer Shreya's question directly, yes, there is this clause present in the jurisdiction, but the problem is uniformity of practice when it comes to using this doctrine.
I cannot hear her.
I'm sorry to interrupt, Shreya, but it seems that you're not really audible to all of us. Could you maybe write a question in the chat box?
Yeah. Am I? Okay, I'll direct the question. It is not a question. Thank you, sir, for the answer. It is not a question. Okay, thank you.
You're audible now. I think you can continue.
Hello.
Okay, so I was just mentioning that Aditya sir very rightly mentioned that even in foreign jurisdiction, for example, in the case of Hoosier Energy versus John Hancock, the New York court specifically refused to execute performance when difficulty was occasioned only by the financial difficulty or economic hardship, even to the extent of insolvency and bankruptcy. The court refused to do that. So now it's upon the convention, and Roy very rightly sir mentioned, to consolidate everything with respect to the present framework. Okay, thank you, sir. That's right.
I think we can take one last question from maybe Tanmay Roy. His question is whether an aircraft can be registered in a jurisdiction if the operator is not from the same jurisdiction, and he asks your opinion on how this issue can be tackled.
General question for anybody?
Yes, sir. It's a general question for all participants.
Okay. My colleague, Mr. Sipos, already mentioned registration in different countries. And I'm not sure which term exactly you used, Attila, about registration in a, let's say, jurisdiction of choice, or a jurisdiction of necessity, a jurisdiction where the aircraft is registered while it is operated continuously in another country. based on Article 83 bis of the Chicago Convention, which makes that possible. This happens a lot. This happens a lot. And not only, how can I say, there are a variety of reasons. And I do know that somehow the fanatics who are focusing all the time on aviation safety, that they have some question marks with this, because I know it myself. I went to ICAO once and talked about it and this and this. And there you meet not aircraft finance lawyers, but the regulatory ones, and they talk about safety, and the whole day safety. Okay. Now, this is great because nobody wants to fly in an unsafe airplane. However, we must never forget that if you don't have finance and lease, you don't have airplanes, except the ones maybe that are paid by the state, what we just said, state controlled. And that is the minority. In other words, you do need financing and money, otherwise we can all close shop, we can forget our business, because then there is no business. So you need it. Now, why do you then go to these offshore, if you wish? State of registration is not same as, and that happens airlines and corporate aircraft. Now, there are many valid reasons to do so. Valid. And I've tried also to explain that to ICAO, because you do it because it creates security, first of all, for the financiers, the creditors, and secondly, it creates also a good oversight over the safety of the aircraft which are operated in risk states. I'll give you some examples. Now, it is not only tax. You want to evade tax evasion. I'm going to talk about it later. And indeed, registration in other countries. But so it is not only tax. It is, for example, necessary if some countries, like Kazakhstan, which is Eastern Europe, if they otherwise cannot operate their aircraft to the European Union. The European Union has a blacklist, and Kazakhstan is one of the countries which is blacklisted. However, it can only operate its aircraft, commercial ones, Air Astana, the national, that is 100% state controlled still, that you can only operate to the European Union countries from Kazakhstan when those aircraft are registered in other countries, which guarantee safety, because the safety oversight of Kazakhstan is apparently still in the eyes of the European Union an issue. So, for example, all the aircraft of Air Astana and their subsidiary, they have a subsidiary, were all registered as a nationality in Aruba. Well, they have never been in Aruba. They have nothing to do with Aruba, but the registration is there. However, permanently operated in Kazakhstan or outside to Europe. Otherwise, you can't do it. And the reason is safety oversight, and that is good. Secondly, it gives the creditors security, the big money makers, the lessors, the owners of the aircraft, and their financiers. Lessors also need money to buy those aircraft, to lease them out. So they need creditors, big banks consortium. Now, they don't want to register there previously, before the war, Russia-Ukraine. They don't want their aircraft to be operated in Russia, registered in Russia. First of all, there is a tax aspect, because your import tax in Russia used to be huge, tremendous. So the operators in Russia could not operate their aircraft. They couldn't compete with other airlines because it was huge amount of import taxes. But also, if something goes wrong, that was the idea always, then you register those hundreds of Russian aircraft in Bermuda or a few in Ireland, corporate aircraft registered in Aruba, Isle of Man, or wherever they are registered. That is another reason, because the creditors who finance this and the lessors, the owners of these aircraft, they want security that if something wrong happens where the aircraft is operated, that at least, that is the idea, the aircraft are registered. Let's say the Russian ones used to be registered in Bermuda and still are registered in Bermuda, but not in Russia, because they were afraid that if something would happen in Russia, then at least the aircraft would have been registered in Bermuda. So that was not supposed to be an argument. Now, we all know by now that the Russians, since they invaded Ukraine, that they stole basically 150 aircraft, at least, that belonged to one aircraft lessor. And I think in total, there were, I don't know how many hundreds of aircraft they didn't get back, etc., etc.
Yeah,
and there are more reasons, and that should be also a very wise for India to do that, to get into an Article 83 bis agreement with another country. So that issue of registration, deregistration of aircraft, refusals, what I'm going to talk about by the Department of Civil Aviation of India, the General GDCA India, happened in the past to create a lot of trouble, that they refuse to deregister for invalid reasons. And that would be good for India to get into an agreement like this with, for example, Aruba. So the aircraft would be registered in Aruba, operated continuously in India, but right now for commercial aircraft in India, that is a no-no, legally not allowed.
Dear Patrick, I'm sorry to interrupt, but you are like a globetrotter. We traveled all around the world. We were everywhere within this few minutes. It's great. I just want to put in this Article 83 bis ABC part just into the context, only 2 sentences, okay? Because of the time is limited. And the answer for this distinguished colleague, Tan Mei Roy. So there are financial leasing and operational leasing, and operational leasing is very popular. And the operational leasing, the lessor owning the aircraft, the burden of the financial risk on the lessor. The lessor has an air operator certificate. The lessor is registered. That everything is a lessor, and leasing the aircraft to the lessee. And is it possible under Article 83 of Chicago Convention, with a separate agreement, not this leasing agreement, with a separate agreement between the 2 governments, that is possible the lessor transfer the right and transfer the operational issue to the lessee. So not to the lessee, to the civil aviation authority of the state of the lessee. So the control and the surveillance and that kind of issue will be on the burden of the lessee state. So they are 2 different jurisdictions, and they can cooperate one another if they have a separate agreement and they deal with this issue under the under the umbrella of the Chicago Convention.
Yeah, but the thing is that safety aspect, as far as the European Union is concerned, and Air Astana, for example, that's a safety issue, because the other, only, I think, 2 air operators in Kazakhstan are allowed to fly to Europe now. The rest, the other ones, local ones, not because they are not registered outside Kazakhstan. But what I want to say is, the thing is that now the state of registration, which is Aruba, for example, that controls the oversight over the local oversight.
Yeah.
So the the technicians of Aruba fly once in a while, occasionally, whenever that is needed. They fly to Kazakhstan, and then they control the local safety procedures, whether indeed that is guaranteed that they meet European requirements. That's what they do. So
Yeah.
locally, of course, day by day happens in Kazakhstan, but above that is the guarantee of a European, Aruba is not in Europe, but it is connected to Europe, that the oversight will be controlled from above down. That is what happens.
Yes, it's true, but very important. We are always in the business minimizing the risk and looking for guarantees. You mentioned the guarantees. One guarantee or more, the registration and the agreement between these two states, two different jurisdictions, has to be transparent. It has to send to the ICAO Council. I'm not talking about Europe, but all of the agreement according to this. And it has to be informed the other states as well. So that is also a guarantee in safety respect. You are not going to make agreement with those states we are not comply with this ICAO standards and recommended practices. Definitely.
But again, the mess in Russia proves that it doesn't help always, right? That is what nobody expected ever to happen. That the Russian government would confiscate, itself directly, indirectly, 500 aircraft which were registered in Bermuda and a couple in Ireland. That is something out of the blue that nobody expected, right?
Always exception, always exception. I said you are always focused exception. I'm focusing on the majority. That is the difference. Thank you very much.
Thank you, everyone. Due to paucity of time, we cannot continue this discussion further for now because we have to break for lunch. Thank you again for this very interesting and enriching first technical session.
Is there 1 minute? I want to ask something because the previous speaker, the last one about the force majeure, or does one have to wait till the end? The force majeure. The gentleman was talking.
Forward in the post-lunch session, Aditya would be joining at that time. He has a class and he has actually left the meeting right now. So he'll be joining at 1:30. So we'll continue from the post-lunch session. Right. Okay. So we'll start sharp at 1:30 IST.
Okay. Yeah. Now?
Yeah, we are winding up for the
morning. All right.
Yeah, all the participants actually will join sharp 1:30 IST. Right. So we'll be carrying forward the debate. And Professor Patrick would also be presenting his paper, and Aditya should also be joining by then. So it can be carried forward. Right. Thank you. See you in the afternoon.
Okay, thank you. Yeah, thank you. And see you later, I guess. That's it.
See you. Yeah.
Where are we? Okay. Hello, sir. Mr. Tyagi, I think you are after me, right?
Yeah, Professor Jackie is after you actually. So he's after you. So welcome to both of you.
Hello, Professor Sandeep.
Yeah, hello.
Hello, Patrick. Yeah, it's a pleasure to be part of this with you. Thank you.
It's a pleasure to hear you both. And yeah, Patrick has already attended in the morning, so he's going to continue from there. And then we would also like to look forward to your presentation.
Well, as far as I'm concerned, really thank you very much for organizing this and inviting me. I mean, it is really a pleasure. I think it's not a second time that you do this. I mean, not in regard to fair financing, but altogether, right? It is second
No, we had
time?
one on the COVID-19, on the impact of COVID-19 we had last time actually. So this time we say about aviation financing. Yeah.
Oh, right. Because, yeah, of course, COVID had a huge impact also on aircraft financing, of course. I mean, it was a total mess. On the other hand, let's be honest, we are lawyers and we need, work.
More cases, yeah. That's true.
And the good thing about this area of law, aircraft finance and leasing, is in the days that everybody is happy, the parties, lessor, lessee, mortgagor, mortgagee, everybody else, they're all happily married. So they are all doing transactional work. Everybody wants aircraft, new aircraft. So then you assist in those transactions, and all of a sudden the marriage is over, and then things break up, or catastrophe like COVID or September 11 or world recession in 2008, the whole collapse. Then we start turning the table and start getting the aircraft back, repossessions, and so on. So let me put it this way, this practice never has ups and downs. There's always something, and I don't remember who said it this morning, but the unexpected, I think it was Attila, something unexpected, something different, never a dull moment, let me put it that way. Never a dull moment.
In nutshell, an aviation finance lawyer would always have the work. No, that's what actually I was trying to tell my students here, right? So because aviation financing, very few people have got the expertise. Many people actually don't even know about it, how exactly to practice in this field and everything. I just actually put forward to them in this way that actually there is no scarcity of business in aviation financing practice. You always be in the business.
You see, that's a very true point. And, this, it is kind of a niche area.
Yeah.
And it is not a huge, aviation by definition is not like criminal law or corporate law or whatever. But then within that, the aircraft financing niche area, specialty, people don't even know what it is. Like my students too. My students, before they get some information from the university, they have no clue. They don't even know what aircraft finance lease means legally, or practically. They have no clue. They can imagine if there is an aircraft crash or there are passenger rights because they are passengers themselves. You understand what I mean? But when you say aircraft finance lease, you see all these eyebrows going up, and they think, what on earth is that? What is it? What does it mean? It doesn't say anything to the majority of people, and also lawyers. They have no clue. And when you talk about it, then they think, oh, really? Oh, really? Oh, really? Even my students who are already practicing lawyers, like right now in the United States, One is a practicing lawyer in LA and also a pilot of private aircraft, corporate aircraft. Another is the director of litigation, aviation, maritime, and space of the Department of Justice, of the Ministry of Justice. He is a director. He has 35 people, lawyers working for him, and his staff in total is 60. He had no clue with all that litigation. He did big litigation cases, like what was it? The aircraft that crashed in Guam. I don't remember whether it is Korean or something like that. So, but aircraft finance? What's that? Huh? You see, people just don't know. And that is why it is good that you pay attention in the academia. You pay attention to it. So that is highly appreciated.
Thank you so much. Thank you so much for that. Yeah.
Yeah. So, on the other hand, we are almost there. It is also good because then nobody knows anything about it. So whatever you say, they'll believe that that's true. I mean, also in court.
Yeah, of course, even in court, that's true. Actually, even the judges don't know. That's why they have to believe it to be true.
They have no clue. They have no idea.
And that's the significance of this conference, I guess.
Sorry?
That's the significance of this conference.
Yeah.
It helped build that awareness.
Yeah, that's true. For the younger generation, for the
Yes.
people who are studying now, absolutely, that is true. That it is not only public law, aviation law, which is, of course, extremely important. There are three pillars, in aviation. One is safety. We all need safe aircraft. Two is tax. Let's not forget tax, because tax is very important. Those objects are extremely monthly billions around the world in regard to financing leasing. You know that. I mean, there's a lot of money going on. So tax is extremely important. But then, last but certainly not least, is aircraft financing law, leasing law, because without money, you have no aircraft, you have no airports, you have nothing, you have no crashes, you have no competition. So we can all really go home and start riding bicycles or whatever you've got in India, donkeys or elephants or whatever, bicycles here in the Netherlands and in China. We can go back. It's time, I think. Do we start now?
Basha, can we start?
Yes, sir, we can start now. It's already 1:30.
Yeah, we'll start.
Okay, so good afternoon, everyone. Welcome back once again. We are about to begin our technical session 2. For this session, we have 2 resource persons and 1 paper presenter. So before I introduce the resource persons and the paper presenter, I would like to make a few announcements. So this is a humble request from our side to the presenters. If it is possible, then please try to maintain the 15 minutes timeline, because we have another session after this session. I know the topics are very interesting and it is very difficult to conclude within 15 minutes. But we have some other speakers in the technical session 3. Then another important thing, just like the previous session, we will have a question answer come a discussion around at the end of this session. So I would like to request all the participants to prepare their questions and put the questions in the chat box at the end of this session, and kindly mention the name to whom you are asking that question. And all the speakers, they can also have a discussion round at the end of the session during the question and answer round. So without wasting further time, now I would like to introduce to you all our first resource person for technical session 2, Professor Patrick Hornweir. He is an adjunct professor of LLM program in Air and Space Law, School of Law, University of Mississippi. Patrick Hornbeer is professor of unique full semester course, International Aviation Financing and Leasing Laws. He joined the International Air Transport Association in May 2019 as an instructor for the course Aircraft Acquisition and Financing. Professor Hornbeer is also one of the founder members of RIP Law Aviation, where he advises major manufacturers, banks, leasers, and airlines in relation to international financing and leasing of aircraft, helicopters, and engines. He was also the expert legal counsel of governments of Aruba, the former Netherlands, Antilles, and the Dutch Ministry of Foreign Affairs. He was also an editor of journal Netherlands Journal of Air Law. So the combination of extensive scholarly legal knowledge and its direct application in practice makes him a well-rounded aircraft finance lawyer. So I would now like to request Professor Hornbeer to take over the mic and give his presentation. Over to you, sir.
Thank you very much for the introduction. Very kind of you. And special thanks to the organizing university, and certainly to Professor Baat for inviting me. I really appreciate this, and I think it is a very important conference. But now, considering the time, my presentation is called, as you can see, Solving the Worst Case Scenario of Aircraft Deregistration in India as provided by the Capitol Convention. And there is somebody, I hope, who will turn my slides. Can you please go to the next slide? That was what I had. Thank you. What I would like to add to the introduction very quickly is that indeed I'm the responsible professor for the course International Aviation Financing and Leasing Laws at Mississippi Law School. And I would like to add that I am kind of proud that this university, LLM, and we have other programs, not only LLM, also other programs, that Mississippi is the only academic institution worldwide that offers this course such extensively. It is a full semester course, lectures online twice a week, Monday, Wednesday, and that, as I say, Leiden, McGill, whichever, but McGill, Leiden, are not providing such an extensive course. And I did teach at Leiden University for more than 13 years. And then what I did was like lecturing for 10 weeks. But since I left, that is no longer at Leiden University. Can we go to the next, please, slide? I want to talk to you today about this particular case. This is the most notorious, the worst case in the history of aircraft financing and leasing practice, and it has to do with India. What I'm going to do today is not India bashing, but it is in India, the conference right now, focus on India, and also the students in India. So my presentation may be somehow critical, but it is happening in India and until today. All right. What is it all about? It is about this privately operated aircraft. You can see the manufacturer serial number, the registration VTRAK. However, I can tell you already that in 2010, this aircraft was taken they did fly it out of India. And since then, it has been grounded for more than 11 years in the United Kingdom. and particularly Biggin Hill Airport, which is in the area of London. Next, please. What is the case all about? It is called the case, let's call it corporate aircraft funding, and then the state of India. And what happened is there was a lessor in Ireland called Pule, a lessee in India of that aircraft, Golden Wings. However, lessors need money, right? Lessors need money, like everybody else, to acquire the aircraft so they can lease them out to their customers, you can imagine. So they also have to get loans. Like in this case, I think they got a loan of like, I don't remember, 14 million, while the aircraft was something like $25 million. All right. So there is a lessor, Ireland, lessee, India. There is a bank in the United States, a mortgagee, and there is a mortgagor that is located in Ireland. Now, that mortgagor, the lessor, was one of those special purpose entities that was earlier talked about. They did that purposefully. They created that company with only one objective, special purpose, owning the airplane, nothing else. It was the only asset. It had nothing else, no staff, nothing. And the shares are controlled by the ultimate beneficiary. Now, all right, these parties, the lessor and the lessee, they defaulted under the lease agreement and under the mortgage agreement. In 2010, aircraft was exported out of India April 2010. And since July 23rd, 2010, it is grounded at Biggin Hill Airport. Okay. The Director General of Civil Aviation India refuses to deregister that aircraft from the Indian aircraft registry, and then until today, allegedly. I must say, I know for sure until recently, but whether today, I tried to find out with my contacts in India, but until today, I didn't get it, whether really today it still is registered in India, and that the DCA India refuses to deregister it. Now, that is a big problem, because you can imagine grounding for 11 plus years an aircraft somewhere, whether it is a corporate one or a commercial one, that doesn't do any justice to that particular aircraft. The condition is bad, or alone the engines. When you start flying it again, it costs millions to get the engines fixed technically, etc., etc. All those costs, you don't get any money because it's grounded for 11 years as a lessor, and you don't get money from the lessee, so you can't pay your bank, so that is why bankruptcy. All right. However, what happened is that in India, the tax authorities, they were alleging that the ultimate beneficiary of that certain corporate aircraft was involved in a tax scam, right? A tax scam. And the name of this person is Lalit Modi. I don't know whether the younger generation know about this, but Mr. Modi, he was the India Premier League Commissioner Cricket. He was the guy that made a lot of money. And now, you know, in India better than I about cricket. Okay, so he got into trouble with the tax authorities because the tax authorities said you are involved in a tax scam and we want you to pay us $2.5 million. In fact, that is 18.79 crore, 18.79 crore, and I guess that is roughly about $2.5 million. The aircraft, by the way, was 100 crore, RS 100 crore, and if I'm correct, it is about 25 million. Okay, now, so the tax authorities said this is no good. And the aircraft is VT, that is India, right? That's the call sign, RIK. And RIK are the initials of the children of Mr. Modi. He wanted registration named after the kids, and the kids were supposedly the owners of the aircraft. So not Mr. Modi himself or his company or whatever. No, he had created in Ireland this lessor, and in India the lessee, and all kind of shady things. As I say, the kids being the owners, of course, was not a reality. So the tax people said, you know what, you must pay about 2.5 million import duties. Now, it went very bad with Mr. Modi, and he and his wife and family left India, as far as I know, and possibly they are still living in England somewhere. In any event, so this aircraft is more than 11 years grounded. For the sake of argumentation, let us assume that it is until today so. All right, can we go to the next slide, please? This was a big issue because the stakeholders, first the lessor, but certainly the lessor financier, corporate aircraft funding, was not happy with this altogether. So the aircraft was already taken out of India, located in the UK, right? But it said to the Department of Civil Aviation of India, it said, we want you to deregister this aircraft so we can lease it out again or sell it to a new customer, a new lessee, operator. So deregister this aircraft because India has adopted in 2008 the Cape Town Convention, and the Aircraft Protocol. And these agreements, there were several agreements in this case, but the lease agreement I'm talking about right now, the last one of 3 in this case, that was falling under the application of the Cape Town Convention. Moreover, the IDERA provision of the Cape Town Convention, which I think was already discussed by previous speakers and how important that is. It gives the right to the stakeholder to exclusively that entity, that stakeholder is allowed to ask a Department of Civil Aviation, in this case India, to say, okay, we want you to deregister that aircraft, and nobody else is allowed to do this. Now, the IDERA document had been lodged validly by the debtor, by the lessee. It had been submitted to DCA India. DCA India had it on its files. So everything according to the Cape Town Convention was followed, right? And that meant that DCA India had to deregister that aircraft. It is mandatory. There is no, it had no choice. It had no power to say yes or no, we are going to do it or we are not going to do it. That is under the applicable provisions of the Cape Town Convention. There is no discretion for DCA India to deregister that aircraft or not. And again, if you don't deregister it, you cannot register it in another country and lease it or sell it to a new interested party. So it went to court. There was a court case, number 1, corporate aircraft funding v. Union India, 2013. And the court ruled, in essence, you know what, there is this Cape Town Convention, which is applicable, an international treaty, and therefore the Department of Civil Aviation, I call it Department of Civil Aviation India for sure, for short, must deregister that aircraft. Okay, however, the tax people, the Directorate of Revenue Intelligence, appealed. It started another case, so against corporate aircraft funding, May 10. All right, what happened here? Obviously, the stakeholders, financier, corporate aircraft funding, surely argued in court, you know what, the Cape Town Convention applies, the IDERA rule of the Cape Town Convention applies, etc., etc. So we ask you to order that Department of Civil Aviation will deregister this aircraft. You can imagine that they did. However, in all his wisdom, this court, a judge, one, he ruled and totally ignored the existence of the treaty. In his ruling, didn't even mention it. Did not even mention it, as, I don't know why. Probably he thought it was too complex or whatever. He didn't know anything about it, because that happens in practice, and not only in India, but that courts don't know, and they prefer not to care about international treaties. So in any event, the court in appeal said, you know, something different, and it did not say order that the DCA India had immediately, within the time as prescribed by the Cape Town Convention, to deregister that aircraft. Didn't do it. Amazing, amazing. Now, next, at one point in time, in 2019, the lessor went bankrupt in Ireland. And as I said, the estate of the lessor was only one asset, and that was that aircraft. It owned that aircraft, which was financed by the financier in New York in the United States. So the lessor went bankrupt, and until today, the Irish liquidator, who was appointed, KPMG, I'm sure you know about this organization, KPMG in Dublin, they did not execute that aircraft, didn't sell it, didn't take it to pieces for spare parts, to sell parts or whatever. It didn't do it. So that aircraft remained on that airport for all those years, costing so much money. Again, parking fees, insurances, whatever. No, so nothing happened. Next slide, please. What do treaties say about this, about aircraft deregistration? Previous speakers already talked about the Chicago Convention, 1944. And in this situation, particularly are of interest Article 18 and Article 19. The Convention International Civil Aviation, Chicago 1944, which is basically the blueprint for law covering aviation, but focusing primarily not only, but primarily on aviation safety. It also covers, and that is often neglected, aircraft financing, little aspects, economic aspects. But in any event, Article 18 said, and that was also mentioned earlier, that an aircraft cannot validly, that word is the most important term in this provision, cannot be validly registered in more than one state, but its registration can be changed from one state to another, right? Okay, so the question is, if a situation arises like the one at hand, where is it at a certain moment registered validly? And not, it can be invalidly registered in 3 other countries. That doesn't matter, but you need to find out, in this case, where is it registered validly when the trouble, litigation, etc. started. Default, when the default started, or bankruptcy at that moment in time, and you ask for deregistration, where is it validly registered? You have to ask yourself that, and that is important. Validly is the most important term in the whole provision. Registration of an aircraft and transfer, so you can transfer, for example, from India to the Netherlands, nationality, deregister, register here, deregister India, register in the Netherlands. Registration is based on local laws, okay? However, the Chicago Convention doesn't say anything about deregistration. It doesn't say anything about it. It doesn't say anything about the process, a uniform procedure for registration either. It doesn't give that. It doesn't give that. It is up to the states, registration, no uniform procedure. However, deregistration, it says nothing. Okay. That means that each country has its own good or bad deregistration rules. Some countries have wonderful facilitating deregistration rules. They cooperate, they will assist as soon as possible, they will work with the stakeholders, while others have bad deregistration rules, locals. And unfortunately, India is one of the countries. You can imagine me talking today, listening to me, that India is a risk country what that is concerned. In regard to deregistration issues, India has proven to be not a good country. It's a highly risk state. Why? It is not only this case, there were other cases previously. Jet Airways, 2019, an aircraft here at Amsterdam Airport. They refused DCA or India to deregister as well. Kingfisher. Cape Town didn't apply to Kingfisher, but there are also issues to aircraft, Kingfisher aircraft. They arrested them in Turkey, Istanbul. The Department of Civil Aviation, India, also had big trouble. And before that. So India, DCA, in the world of aircraft finance and lease, globally has a reputation. In any event, so you have good laws or bad laws. India, not so good. However, unless, as you can see on the bottom, unless a new self-executing ICAO-endorsed treaty dictates a uniform deregistration procedure for all its member states that are a part of this treaty and have made a certain declaration that the IDERA rule, for example, can we go to the next slide, please? IDERA rule will be applicable. Now you can see Cape Town here I'm not sure what the other speakers have been telling you about this, but plus 80 countries and the European Union to a certain extent. Then the Cape Town Convention provides for a uniform legal regime for export and deregistration of aircraft. And that is mandatory. That is mandatory, obligatory in India and other countries where this IDERA rule applies. And that is in many countries, as you can see. And India is one of them, but India is not doing its homework. It should do this, but it just doesn't do it all the time. Can we go to the next slide? Which Cape Town Convention deregistration process applies to the VT-ROC? Now, the Cape Town Convention uniform deregistration procedure, I told you. And I say here below, why not yet Greece, as it is currently considered to be an aviation finance risk state? I use Greece because Greece is one of the states that is known to be risky, when you see documentation, financial documents of aircraft lessors and banks, which they publish annually, half annually, quarterly to their shareholders, etc. One of the countries I just mentioned at random, Greece right now, Greece is one of them. It is seen as a risk state. And then you may wonder, why does Greece or other known risk states in Europe or elsewhere not adopt this treaty? Why don't they do this? Now, because if they do, there is the possibility of the IDERA, the irrevocable, the debtor cannot revoke its permission which it gives to the Indian authority that the stakeholder in question is the one that can only ask for deregistration and nobody else, and at the time that the stakeholder wishes to do so. So there is no issue of, oh, is the lease terminated properly? Is the tax paid properly to the Indian tax people? Is this or that? No. It is purely documentary in kind. It is not at all regarding the safety of that airplane. Of course, the airplane must be safe. Those rules, regulatory, must be observed if the airplane will be flying again, if it will be flying out of India, or if it will be operated again, like in this case, out of London. Yeah, but that has nothing to do with this deregistration, purely documentary, nothing else. Okay. The IDERA was recorded by DCA India, and that protects the authorized party, we call it, the authorized party, only that party which was corporate aircraft funding, the mortgagee, that could do and ask for deregistration. Now, they did so, corporate aircraft funding, but DCA refuses, okay? And all inspired by the tax people, the tax division, the tax ministry, the tax department, whatever you call it, internal revenue. They said, no, you can't do it. No. We want 2.5 million, otherwise you can't do it. And the lessor, of course, the bank said, why would I pay for the debts of that operator? I'm not involved in this tax scam. I'm not involved in duties that I have to pay for import. Why do I have to do that? I'm not going to do it. And I've got the IDERA obligatory. You're a Cape Town state. You should do your homework. You should deregister. Now, but I think that what, at least in my, because DCA has no discretion, I told you, no discretion. It must cooperate, and the law says in Cape Town Convention protocol, swiftly, not 10 years waiting, right? Swiftly, okay. And that is, in my book, in my thinking, argumentation, it is a tort. It is tortuous because it is infringing international law which applies in India since 2008. And that is a tort. So in my country, if this would happen in the Netherlands, in Europe, where I'm located, I would advise my client, you better now sue the Department of Civil Aviation for all the losses, because it is not doing, it's neglecting its duties under the law applicable. And that's a tort because I'm damaged, and severely. That means that by operation of law, Cape Town Convention, that aircraft, this one, is no longer by operation of law registered validly in India. Whether it's still in the system of the computer in India or whatever, doesn't matter. That doesn't matter. Whether it is in a book and they didn't by pen, I don't know. In some countries they do it in writing. They have a book still, and they say no longer registered or whatever they do. Doesn't matter. Doesn't matter whether the Indian authority thinks it is still in its books or in its computer. Nothing to do with that. It is invalid. So that means this aircraft is no longer validly registered in India. Can we go to the next slide? So what does that imply? If the Cape Town Convention IDERA provision applies, you can register that aircraft in another country, because then it will only be validly registered in that new country. Now, the Netherlands is the only country in the whole world so far, since 2020, that has implemented the IDERA rule of the Cape Town Convention in its local law in a unique new way that nobody else has done yet. And this took a long time. I was the external advisor of my government in the Netherlands in regard to this implementation of the IDERA provision. We didn't implement any other provisions of the Cape Town Convention, only the IDERA provision. Otherwise, you don't have to in my country. There's no need for that. There's no need, because treaties have priority over local law. If local law infringes a treaty, local law will not be applied. As simple as that. It would be good for India to have that in your constitution, but I guess it will take a few weeks to change that, if you get my drift. In any event, so you don't have that system. Now, what is now the new law say of the Netherlands? And it took us 5 years to do so, to get that law, because there was a lot of resistance and fear. What are other countries saying? How will that be? What is ICAO saying? What is this organization saying? What will our neighboring states say in the European Union? So my government inquired, ICAO, Canada, for example, other countries, and they all agreed, whoever was we talked to. Okay. New law now since 2020. When you import an aircraft in the Netherlands, sorry, it's important. Proof must be submitted that the aircraft, one, the aircraft is not or no longer registered abroad. Now, yeah, that is normal, right? You've got that too in India. All countries have something similar. You have to prove that the aircraft is no longer registered abroad. And you can do that in any possible way, in my country at least, that you prove the aircraft is no longer registered in India, for example. And usually you do that with a document saying, certificate of deregistration, aircraft is no longer registered in India as from that date. Bang, that's it. And now it comes. Or, and that is new, aircraft must be deregistered from the foreign registry, India, under the Cape Town Convention IDERA rule. This is very much simplified. The text is more detailed, but it comes down to it. So in the Indian situation, corporate aircraft funding, this is applicable. There it must be deregistered, says Cape Town, but it isn't deregistered, says Cape Town. Okay. And 3, the authorized party, the bank, has duly asked the Department of Civil Aviation India to deregister, which is refused. And it is refused in India for 10 years, 11 plus 11 years, more than 11 years. Now, so then you can register in my country that aircraft.
Sorry to intervene, but sir, I would like to request you to kindly wind up because
Yes, I am doing so in a couple of minutes, then I'm fine. And I'm sure I'm not the only one that is passing this morning 15 minutes, so please give me a chance.
yeah.
Or the applicant must also be domiciled in the Caribbean Netherlands. The Netherlands is like the United Kingdom. It has overseas territory still, crown dependencies, whatever you want. But there the Cape Town Convention applies. So the applicant, the new owner or the owner who applies for registration here has to be domiciled there. That means you start a special purpose vehicle. If we've been talking about this, a special purpose vehicle which will own that aircraft. And then you ask for registration and you will exploit it there, which means you don't have to fly it, it doesn't not have to go there. No, you can manage it or whatever, lease it out or whatever. But the regulation is not applicable in other parts of the Kingdom of the Netherlands, like Aruba, and that is often confused. Can we go to the next slide? As far as I know, we are really almost there. Concluding remarks. Practical consequences of the new regulation. What is it? Now, the aircraft will be temporarily, like this one, will be temporarily registered in the Netherlands. How long? A month, 2, 6, whatever you want. It obtains the flag of the Netherlands. And Netherlands is a European state. It is highly esteemed, safety-wise and everything else. It is a very good reputation. It is not some obscure whatever country. So you'll get the flag of the Netherlands, right? Later you register it and lease it out in a party in the US, in Asia, of course not in India. You don't want to do business anymore if you experience this, right? You don't want to go back to India. Okay, so your aircraft will never go back to India. Otherwise, the tax people will arrest it probably. Now, the new law of the Netherlands therefore can facilitate global deregistration of aircraft problems, assuming that proper records are available. You need records of the aircraft, otherwise the aircraft is worth nothing. But this is not only for a situation like India, this case, Jet Airways, etc., Kingfisher, whatever. No, other also risk state. Can we, and we are the only country having implemented it so far, and I would recommend that other countries follow up. Next slide. Now, then look, the only REP law are the only team exclusively focusing on aviation in all the units of the Kingdom of the Netherlands. And we are the expert. So don't go to lawyers that you may have aligned with and they have nothing in their mind what to do, how to do, because like in this corporate aircraft funding, this is the last thing, I'm ready, case, we have offered the stakeholder of the corporate aircraft funding aircraft a year or so ago to assist them. We could solve this case that was pending for 11 years. We would be able to give them their aircraft and new registration in what, let's say 2 weeks to a month. And our government, highly officials, also were willing to guarantee that we would cooperate. But what happened is that the stakeholder, the bank in corporate aircraft funding, had solicited legal advice before we came into the picture with another law firm in the Netherlands who knew nothing about this and who gave them bad advice. So they said ultimately, the stakeholder in New York, the bank, yeah, but we have bet this, this, and this. So they didn't do it. But that is a decision of management. That is not what we do as lawyers, give legal advice. And if the management then makes wrongful decisions, because that aircraft is probably still registered in India, I'm not sure 100%, but I guess so. And we could have solved their problem already 2 years ago. And that's it. Thank you very much for listening. And I don't know if I have been a lot over time. Sorry for that.
Thank you so much, Professor Hornbill, for giving us more insight on the Indian practice on the Cape Town Convention. And you have discussed it very well. So thank you so much for that. Now, I would like to introduce to you all our second speaker for the day, Dr. Divya Tyagi. He is an assistant professor of law at Gujarat National Law University. Not only that, he is also the head of V.S. Money Center for Aviation and Space Laws. Dr. Tyagi teaches several disciplines including air and space law for the UG and PG program. He has an extensive record for presenting papers before conferences and seminars on several aspects of air and space law. He has also served as the convener for several editions of the GNLU Air and Space Law Academy and accompanying conferences. So now I would like to request Dr. Tyagi to take over the mic. Over to you, sir.
Thank you, Barsha. Let me share the slide. Is it visible? Are the slides visible?
Yeah. Yes,
Yes,
it is.
Okay, thank you. Thanks, Professor Sandeep, for this opportunity to share thoughts on this area. And I learned from your invite, your nomination to UNIDROIT. So my congratulations on that front as well. I am mindful of the instruction given by Barsha with regard to 15 minutes, so I will try and confine to the time. Good afternoon, everyone, and a warm welcome to this presentation. Compared to the previous presentation, this is a little promising story unfolding in India, in Gujarat itself, from where I'm speaking. So this presentation actually highlights some of the efforts, though not exhaustively, with regard to the work that is being done, particularly in IFSC Gujarat, in terms of developing IFSC Gujarat as aircraft leasing hub for India. The presentation will be structured in two parts. First, I'll be speaking about International Financial Services Center, and then I'll be talking about some of the measures that are undertaken under this framework in order to fulfill the objective of making India an aircraft leasing hub. As has been pointed out in the presentations before, and very rightly put in context by Professor Sandeep himself in the morning, although we are the third largest aviation market in terms of domestic operations, we continue to be relying heavily on leased aircrafts. And obviously the consequences are that the aircraft leasers are based out of India. Now, few jurisdictions are mentioned in the slide. There are others as well, but then to name few. It has consequences in the form of substantial liabilities for Indian players. That too is payable in foreign currencies, which is subject to currency fluctuations as well. And now, to put things in perspective, International Financial Services Center is something where we are providing financial services to non-residents and residents in any currency except Indian rupee. So that's the important parameter for a financial services center. And idea initially was explored by government of Maharashtra when they constituted Percy Mystery Committee with regard to establishing an IFSC in Maharashtra, Bombay in particular, because that's the financial capital of India. However, it could not be worked out. Particularly acquiring land for this purpose was an issue in Mumbai, as we understand the difficulty there. And so therefore, it was around that time that the then Chief Minister of Gujarat, Narendra Modi, now Prime Minister, actually took the lead and established it in Gandhinagar. Certain milestones in this journey, when they started it, the idea was that financial services, as we understand, includes the banking services, the insurance services, and the securities market, stock exchanges. So therefore, you will find that although the initial contours were laid down by Ministry of Finance, but then the three regulators for these different sectors, that is RBI, SEBI, and IRDA, they came out with their respective guidelines so that this IFSC starts functioning. And so therefore, a very important development. Government also realized that tax incentives have to be given. So exemptions were given from number of taxes, so dividend distribution tax, securities transaction tax, gains from transfer of long-term capital asset, commodity transaction tax, and no exemption from MAT, that was kept at 9%, but was comparatively lower. Then thereafter, it was realized by 2019. In fact, the realization was there from the beginning that if we really want to develop this as a financial services sector, which is going to compete with IFSCs across the world, then in that case, we need to have an independent regulator for this center. And you have to go beyond a regulator which can think exclusively from the perspectives of developing it. And so therefore, this also was realized in 2020 when they established it. 2019, they have come out with law. Idea was very clear, ease of doing business. They wanted to promote, and they wanted to also provide world-class regulatory environment. But then when you establish an independent regulator, you do not want to dissociate yourself completely from the experience of your existing regulators. So RBI, SEBI, IRDA, PFRDA, their representatives are ex officio members of IFSCA, apart from other members. And one of the power given to IFSCA is under section 21A of, section 12A1 of this IFSCA Act, which is to develop and regulate the financial products. How was the response? Very interesting. Media reports indicate that by June 2022, at least 300 country entities have set up operations under the ambit of IFSCA. So very promising response once the regulator was established and it started functioning in its full scope. And then we have succeeded in the sense that 13 fintech entities are there, 2 stock exchanges are functioning, 1 bullion exchange is functioning, 12 IBUs, international banking units, are functioning. And then ancillary establishments have also come into existence. Interestingly, when it comes to Global Financial Center Index, March 2022 indicates that we are ranked among the top emerging global financial centers. So far, the story has been promising. When we contextualize it in the context of aircraft leasing, then somewhere in 2020, Government of India notified aircraft lease as a financial product, and that sets the tone for locating aircraft leasing activities in IFSC. So you build a framework and then you further contextualize another framework over that framework. That is how it is. As was pointed out in the previous session, aircraft lease, we talk about operating lease, financial lease, and hybrid mode is also permitted here. And then there are 3 framework existing under IFSCA. The first one is the IFSCA Banking Regulation 2020, and then IFSCA Finance Company Regulation 2021, and then IFSCA has also come out with a framework for aircraft operating lease very recently. Now, when we look at the banking regulation, what are they talking? They require that you apply for setting up a banking unit in IFSCA. IFSCA will grant approval. Permitted activities for these banking units include, inter alia, undertake equipment leasing, including aircraft leasing. So that's how they tweaked it and brought it in. General prudential requirements will be as prescribed by IFSCA. When we look at the IFSCA Finance Company Regulations 2021, we find that you can establish a finance company either as a subsidiary or a joint venture or a newly incorporated company under Companies Act in any other form, but then you have to take a certificate of registration from IFSCA. Whereas if you want to establish a finance unit as distinguished from a finance company, then you can set it up as if the applicant is an incorporated entity in its home jurisdiction, then you can establish. Prudential regulations, again, as a regulator prescribes, there are permitted core activities and non-core activities. Now, operating lease falls under permitted non-core activities. There are additional requirements for non-core activities. For example, you have to segregate the department, then you have to ensure that there is a firewall to avoid conflict of interest, and then grievance redressal and customer compensation policy has to be there, which has to be approved by the board. And then every finance company and finance unit will have to adhere to the corporate governance and disclosure requirements, obviously prescribed by IFSCA. When it comes to aircraft operating lease is defined any piece of mobile equipment designated, built, and used for ground handling, servicing, or field maintenance of aircraft on the ramp area of an airport, and includes any piece of ground support equipment, and then also equipment used for providing services necessary for ramp handling. And then, as per explanation, aircraft ground support equipment is what it will be collectively referred as. Then operating lease transaction, permitted non-core activity under finance company regulation that I have mentioned already. Financial lease transaction, permitted core activity, which will include hybrid as well. You have to facilitate setting up of an aircraft leasing business in IFSC. So incentives are given. I'll be referring to that a little specifically subsequently. In order to get registered as a finance company or finance unit, you have to adhere to the finance company regulation, something that I have already spoken about, for undertaking aircraft lease transactions. Now, a leaser is defined. I'm not reading for the paucity of the time, but then someone who is engaged in the business of providing aircraft, helicopter, and engines of aircraft or helicopter, either part thereof, and aircraft ground support equipment, operating lease, financial lease, hybrid, and then any other related activity. Eligibility, you can be a company, LLP, or a trust, or any other form. If you're a company, then promoters should be located in Financial Action Task Force compliant jurisdiction. If you are LLP or trust, then partners or trustees must also comply. And if you are an entity in IFSC which intends to undertake aircraft lease only through its wholly owned subsidiary set up in IFSC, then you will be deemed to be a lessor. Apply and take permission under this framework. Further, this operating lease will include sale and transfer, sale and lease back, purchase, novation, transfer, assignment, and such other familiar transactions. Operating lease for an aircraft ground support equipment and asset management support services are also included. And IFSC has discretion to permit any other related activity. There are capital requirements mentioned. I'm skipping it for the sake of time constraint. And then currency has to be freely convertible foreign currency only. I have already mentioned about this in the beginning. There are certain statements which are to be filed before the regulator under this framework. And then very importantly, in the context of this conference, Cape Town Convention and Protocol, you have to comply. So that is directly applicable under the framework, and your resources should be commensurate with your business operations. There are a number of tax incentives also given through budget proposals by the government. So for example, if you are an aircraft leasing unit, 100% deduction from its income. for a period of 10 consecutive assessment years out of the first 15 years, and then you can choose the 10 out of the 15. Secondly, if you are opting for concessional tax rate of 22%, then in that case, you still have the option to avail the benefit of the 10-year tax holiday period mentioned before. And then if you are an aircraft leasing unit in IFSC which has earned capital gains from the transfer of an aircraft or aircraft engine previously leased by it to any person, then the aforesaid tax holiday period is also applicable to it, provided it has commenced its operation by 2024 March. And MAT rate of 9% is there. I have already mentioned about it. An aircraft leasing unit supplying aircraft for importing by an Indian airline operating company is not subject to basic custom duty, subject to the condition that the aircraft is imported for scheduled air operations. That's on the indirect tax front. Then royalty or interest income derived by the non-resident from leasing an aircraft to an aircraft leasing and financing unit in IFSC is also exempt, provided you start commencing operation by March 2024. With regard to withholding of tax, not required on such aircraft lease payments in the nature of royalty or an interest payable to such non-resident, and aircraft leasing unit in the IFSC would not be subject to basic custom duty at the time of procurement of aircraft or its parts thereof, parts from outside India. Now, many of these incentives will be of particular interest in the context of aircraft leasing. Response, well, 13 aircraft leasing companies, as per media reports, are already operational. Few examples I have mentioned in the slide. 11 aircrafts have already been leased, so positive response. Where do we go from here? There are challenges still, because you have to compete with IFSCs, which are far more experienced than us. So therefore, number one, the challenge is, as I understand it, RBI needs to incentivize finance to fund the transactions. Unless that will happen, it will be very difficult to be developed. Then parking facilities, clarity has to come with regard to these facilities available for aircraft provided to leasers registered with IFSCA and associated cost also. Then there has to be clarity with regard to lenders of an IFSCA registered lessor in the event of bankruptcy and insolvency. We need to also look for a very enhanced and close coordination amongst the regulators, namely IFSCA, DGCA, and AAI. You have to also create incentives for development of ancillary sophisticated products and infrastructure within IFSCA, and then only the entire ecosystem will come into existence. And you have to also, as a government, encourage the entrepreneurs to start aircraft leasing and financing activities. The last point is that although these developments are happening, but not much scholarly analysis are undertaken on these developments. So therefore, one of the purpose was to trigger that debate through this presentation. With that, thank you very much. I look forward to the questions and observations. This being a new area, it's very important for us to deliberate. And not only that, as a university, we have been very closely associated with this development because it's just across one Sabarmati River bridge. And so therefore, we have seen how government has talked to stakeholders and then developed it. I am very optimistic about this development. And with that, I conclude. Thank you.
Thank you so much, sir, for such a brief and beautiful presentation. You have discussed the various problems associated with the foreign investment in the aviation sector and, of course, the role of IFS in this regard. And you have also provided your valuable suggestions for a better future. So thank you so much. And now I would like to introduce our first paper presenter of the day, Ishita Das. She is an assistant professor of law in Nalsar University of Law, Hyderabad. She has done her LLM in the year 2018 from WBNUJS. She was the gold medalist of her batch. She has a special interest, a research interest in the field of aviation law and space law. She has presented many papers and she has many publications in the area of aviation law and space law. She was the first runner-up at the first Dr. APJ Abdul Kalam Air and Space Law and Policy Essay competition presented at the Nalsar University of Law, Hyderabad in the year 2020. She has also won the first prize, first national legal essay competition for essay title Soaring in Stormy Skies, International Aviation Disputes and the Role of the ICAO, organized by the Law College, Dehradun, Uttaranchal University, in association with the International Law Students Association in the year 2018. So now I would like to request Ms. Ishita Das to take over the mic and to present her topic. Ishita Das.
All right. Can you hear me?
Yeah, we can hear you.
Thank you so much for that very wonderful introduction. I'll just quickly share my screen. I'm assuming that it's visible to everyone.
Yes, it's visible.
Okay. All right. So before I begin, I just want to quickly convey my gratitude to Professor Bhatt for inviting me to be a part of this very lovely conference so far. I would not take up too much time. I would try to stick to the 15 minutes allotted to me. So what I'll do is, before I begin, I'll just quickly clarify a couple of terms, key terms that I'll be using throughout my presentation. Okay, all right. So in a sense, right, so my topic, as is very clear to all of you, is essentially about the concept of insolvencies. So what I'll do is I'll use the two terms, insolvency and bankruptcy, interchangeably. So insolvency has a financial connotation to it. Bankruptcy has a legal connotation to it. So I would not really make any distinction per se between these two terms. So essentially, the whole idea that I'm going to try to explore, right, over the course of this remainder time that I have with you, is how do we understand the concept of insolvencies, and how do we distinguish this concept from corporate insolvencies, and what are the legal challenges, what are the different instruments that we have at our disposal, what is it that India needs to do better, what is India currently doing with regard to the entire insolvency regime, right? So that's going to be the focus for this presentation. So very quickly, let's start off with the first slide. Okay, all right. So at the very outset, I want to clarify that airline insolvencies are very different from corporate insolvencies. And the primary difference stems from the fact that corporate insolvencies might not involve a very huge array of stakeholders. So in a sense, a corporate insolvency could be very well restricted to the company itself. So hence, we're going to talk about essentially the creditors. The creditors could of course, be spread out over the entire spectrum. However, the corporate debtor, right, could just be one stakeholder in the entire process. However, when you're talking about airline insolvencies, and given that you already know by now how there could be multiple stakeholders, how there could be this entire concept of leasing out, and how there could be involvement of a special purpose vehicle, there could be involvement of a partnership firm, and of course, creditors spread out across multiple jurisdictions. So given that we're looking at so many stakeholders across so many jurisdictions, it can be quite problematic to arrive at one particular solution or to have a very one-size-fits-all approach when it comes to insolvency. Now, Dr. Tyagi has painted a very rosy picture, and the fact that he's very optimistic, I'm really glad that you said that and that you share that perspective. However, I would like to present a slightly different perspective when it comes to at least insolvencies. So in a sense, what I'll do is I'll share a couple of case studies with you so that you can understand where is it that we stand. What are the different laws that we have used to understand the concept of airline insolvencies, how we have dealt with them in the past, and how do we plan to possibly go ahead and take it a step further. So the first point that I want to essentially highlight is that given the multiplicity of the stakeholders in question, airline insolvencies can be a pretty complex affair and a pretty intriguing affair, right? Especially if you're talking about foreign creditors. So now the question is, how do we make it easy, right, for both domestic creditors as well as foreign creditors? So that's a very important concern that we need to essentially address. The second important concern that I want to highlight is that if, let's say, we're talking about our dependence on international instruments, to what extent can we depend on it? Do we need to have it in the form of a domestic law, right? Or do we need to essentially only restrict our understanding to the current laws that we're using? For example, the Companies Act 2013, it could be the IBC as well, right? So we essentially also have to understand that the psychology behind the creation of these instruments and whether they were broad enough to cover airline insolvencies within their fold. So that's something which I'll be focusing upon. Now, let me quickly move on to the next slide. Okay, all right. So the primary instruments that I'll be talking about are the Cape Town Convention and the Aircraft Equipment Protocol. So I won't really talk about the convention per se, and I think this is something that has been already highlighted by the speakers before me, right? What I will focus upon is Article 11 of the Aircraft Protocol to the Cape Town Convention that specifically focuses on airline insolvencies, right? So that is something which is going to be extremely important for us. So essentially, there are two alternatives that are going to be available under Article 11 of the Aircraft Protocol. First, you have Alternative A, which basically provides the rights to the creditors to take repossession of the aircraft if the default period, right, lapses. For example, if the waiting period, right, is 60 days, which is the case for India, and if the creditor has not been able to pay off its debts within that particular period of time, then the creditor has every right to go and seek the repossession of the aircraft. So that's Alternative A for you. Alternative B does not really create a right per se. It only requires the provision or furnishing of a notice, right, wherein the creditor may take repossession. However, it does not really talk about any right per se, which is provided under Alternative A. So what I will be focusing upon is that Alternative A presents a very, very beneficial scenario, right? And how do we incorporate this in the domestic field? So that's going to be something which I'll focus upon very shortly. When it comes to the Companies Act, right? So we had the earlier act, we had Section 433 under the Companies Act 1956 that dealt with the different circumstances that could lead to winding up. Then you have the Companies Act of 2013 that talks about the concept again of insolvency, etc., under different provisions such as 271, 272. When it comes to the Insolvency and Bankruptcy Code, it lays down a very, very detailed guideline, and it is a very comprehensive code that essentially deals with insolvency and bankruptcy, right? So there are different provisions. For example, you have Section 7, through which you basically institute the insolvency proceeding, and then you have other provisions down the line. So I'll talk about that very shortly. Let's move on now. Right. So I want to quickly highlight this quote, right, and the importance of understanding that, especially in India, the whole concept of promise, the whole concept of, let's say, credit being provided to certain companies based on, let's say, just the issue of trust or promise. That is something that we need to take more seriously. I won't really talk about the Nirav Modi case here, right? However, it is a very, very important concept here, because the whole concept of credit, financing, all this rests upon certain very core pillars related to trust, right? So that's something that is really important for us to also factor and take into account. All right, so I'll just quickly take you through the different case studies, right? So first is, of course, the Kingfisher Airlines case. Very, very, I would say, very, very important when it comes to understanding the pre-IBC scenario, right? So before the Insolvency and Bankruptcy Code came in, how is it that in the Aeratron Limited versus Kingfisher Airlines Limited case, right, which was decided by the Karnataka High Court, how is it that the company was decided to be wound up as per Section 433 clauses E and F and 439 of the Companies Act 1956, right? Of course, we already know the dimensions associated with this case. I won't really go further because of the paucity of time. Jet Airways. So Jet Airways represents a very, very prominent case, especially if you're talking about the post-IBC scenario, right? So a very important development that I want to quickly highlight, don't really want to go into the entire facts of Jet Airways versus SBI. However, I do want to quickly highlight that the Dutch administrator, very, very interestingly, was allowed to be a part of the Committee of Creditors meetings And there were parallel proceedings that were ongoing both in India as well as in the Netherlands. And that represents a very, very important scenario, especially if you're talking about cross-border insolvencies. So very interestingly, there was this agreement that they had entered into, and then they were working as per the directions of the NCLAT. So this was Jet Airways for you, right? Let's move on to SpiceJet. Now, when it comes to SpiceJet, so SpiceJet, very interestingly, is still dealing with this entire process, and it's currently undergoing a restructuring process. They've already paid off a couple of their very, very important creditors. So let's see how this essentially pans out when it comes to in India's sense, right, of airline insolvencies. Quickly taking you to two different jurisdictions. One is UK, the other is Germany. Both Monarch Airlines as well as Air Berlin represent very, very important airline disasters that have resulted in tremendous losses to the passengers. So now passengers can face two categories of losses. One is, of course, welfare losses. For example, if they are stranded, right? If the flights are not flying. Secondly, they could also suffer financial losses due to loss of tickets. So, for example, in the case of Monarch Airlines, the Civil Aviation Authority in the UK, they had to unfortunately undertake a very, very massive and a very, very financially intensive peacetime repatriation exercise to get the people who were stranded, right, abroad to their territory. And that is something which is extremely important for us to understand, that whenever you're talking about airline insolvencies, you're talking about huge financial implications here, not only for the company in question, right, but also for all these stakeholders, especially the passengers, the thousands and millions of passengers who could be so affected. Same goes for air. Very importantly, this problem, right, started due to the lack of funding provided by Etihad. And this is again a very important case study that we need to keep in mind when we're trying to understand how do we deal with the problems here in India. So very quickly, I'll take you through the different stages under the IBC. For example, we start off with the initiation of the corporate insolvency resolution process, generally under Section 7 of the IBC. Then we have the imposition of the moratorium period, wherein no legal proceeding can be instituted against that particular company. And then we have the appointment of the interim insolvency resolution professional, followed by the constitution of the committee of creditors, followed by the passing of the control to the IRP as well as the COC. And then you have finally the approval of the resolution plan that the COC reaches, right, by the adjudicating authority. So this essentially represents a very brief, I would say, mechanism, right, under the IBC as far as the process is concerned, insolvency process. I'll just quickly highlight a couple of challenges and then we'll move on to the solutions.
Ma'am, sorry to intervene, but you are still on the first slide. So can you please share the other slides with us?
I have been, okay.
Okay, so maybe there are some technical issues.
Okay, because I have
yeah,
been...
Yeah, now we can see,
Oh, this is so sad because I did move all my slides. Okay. All right, so these are the different slides, right?
Yeah, now we can see.
So what I think I'll do is I'll just continue like this for the remainder time. I'll probably take about 5 minutes and then I'll wrap up. Right. So we've already discussed the stages, right? So very quickly, I'll deal with the challenges under the IBC now. So as I've already highlighted, right, airline insolvencies represent a very important problem given the fact that this again represents a very capital intensive sector, right? So for example, the moratorium period that is specified under the IBC is 180 days, which could be extremely challenging for an airline, right, given the kind of capital costs that it may incur over the course of this entire period. And it's also extendable by 90 days, which again adds to the entire dilemma, right, of this entire huge, I would say, time period that could be possibly beneficial for the corporate entities, however, not so when it comes to the airlines. When we move on to cross-border insolvency, while there is much talk, debate, and discussion regarding expanding...
Ma'am, sorry to intervene you again. We are running out of time, so if you can, then kindly wind up.
I'll just wrap up in about 2 minutes. Is that okay?
Okay.
Yeah. So cross-border insolvency, right? So essentially, the IBC only contains two provisions, 234 and 235, which are again not very sufficient. It only talks about bilateral agreements. It talks about issuance of letters of requests. Doesn't really lay down a detailed regime, and this is something that we could possibly address if we adopt the 2018 bill that has been proposed, right? Wherein India can adopt the Cape Town Convention, including its protocol, right? So essentially, two important challenges that can be dealt with the new law could be the concept of repossession, wherein instead of the waiting period of 180 days, we'd now have the 60-day waiting period, which is the mandate as per the protocol. And then we can also have the cross-border cooperation, because here we essentially have the concept of international interest, right, which was not adequately addressed under the IBC. Now, very quickly, I'll just conclude by saying that the main mechanism that I think could possibly work for airline insolvencies is the fact that we need to adopt the 2018 bill and we need to enact it into law as quickly as possible, so that we can have a very, very unique mechanism to airline insolvencies. Because corporate insolvencies, right, even though they are, I would say, adequately addressed, at least the domestic insolvencies, even though they're adequately addressed under the IBC, that does not represent the same scenario for the airline insolvency. So I think this is the best way forward. And with that, I would like to conclude. You're free to get in touch with me. My email address is provided here in my last slide. Thank you so much for the opportunity once again. All right.
Okay, thank you very much for such wonderful discussion. Now, I would like to request all the participants, if they have any questions, they can ask the questions. We have 10 minutes time for the question answer round. And they can also mail their questions to the speakers if they want. We will have a question answer round for 10 minutes because now it's already too late. So participants, if you have any questions, please put your questions in the chat box.
Let me just intervene.
Yes.
Right, so I just shared actually two links. And this is connected to both Professor Patrick's presentation as well as Ishita's presentation. Ishita, it is not just a 2018 bill, we have a 2022 bill. Currently, actually, this year itself, actually, we have a new bill. 2018 was about the implementation of a Cape Town Convention, but now it is on the protection and enforcement of interest in the aircraft objects bill. There is a new bill which has been drafted in 2022. This year's bill itself, it is pending actually. As far as Professor Patrick is concerned, I think probably we should be able to have the process of deregistration in place. 2022 bill basically speaks about it. I have given the link therein. You can go through that. Article 15 of the bill basically speaks about it. You can go through the chat box. You can find the link therein. And with respect to India's contravention of UNIDROIT or maybe the Cape Town Convention and the aircraft protocol, of course, the High Court was actually, I mean, it didn't even look into that. Actually, you are right in terms of that. In the judgment, you don't find anything analyzed in terms of the UNIDROIT system. The judges have completely failed to understand that we have a international obligation which we need to comply with. However, there is a declaration which India has deposited along with its accession. That declaration is also available in the 2018 draft. I have sent the link of that as well, actually. 2018 draft has the Indian declaration during the accession to the UNIDROIT Convention and the protocol, which has got exception under Article 39, Article 39(1)A and Article 39(1)B. Under both of them, we have got the declaration, and also under 40. So there might be a possibility of actually arguing under both those declarations for the purpose of justification of its action under the UNIDROIT system. So this is what I just wanted to clarify about the Indian position. Thank you. So others also, whoever is interested, can go through the link. Both the links are available therein in the chat box. Please go through them. Right. With respect to Indian declaration, go through the 2018 draft. In all probability, in future, actually, this problem should be sorted out. The deregistration process should be in place if we accept this 2022 bill.
Yes, thank you very much, Professor Sandeep. It is really impressive and really clear, this declaration which lodged by the Republic of India under the Cape Town Convention when they deposited this instrument, and it is very clearly understand. I would like to add something, if I have just a few minutes, to Patrick Hannobier, because I would like, not asking now, I would like just add something. You know, when we're talking about, and this is very good lesson, because it was mentioned, the lesson for all of you, I was lucky to work in ICAO, and I was involved in the safety audit oversight system. And of course, there is security audit system as well. And it was mentioned by Patrick Hanobier, professor, my good friend, is the airworthiness procedure manual and the deregistration process, how has some deficiencies. And when I compare the Netherlands and Indian situation, but I always, when I'm listening somebody who's talking about different states, I always go to the ICAO website and always open the ICAO audit reports. The ICAO audit reports tells everything about the states. It is transparent. You can do it as well. You can compare the neighboring countries. You can compare Netherlands, India in just 2 clicks. So if you go to the ICAO website and look at the safety audit system, you can see how India made outstanding report regarding, for instance, legislation. Outstanding report. And if you compare with the Netherlands report, we found some deficiencies, but I don't want to involve this just, but I would like to tell the licensing, the airworthiness, and that kind of certification issues are always issue everywhere in the state. And as India is now audited today, I just checked by my colleagues, now the IQ auditors in India right now, and they will finish the audit, and they are focusing for the licensing and certification issues within few days, and they will report the audit report, and this audit report immediately put on the internet website, and everybody can see it regarding the results. What I see, India is above the ICAO standards, above the global average, which is a very good position together with the Netherlands. So why I'm going to talk about this? Because if there is a deficiencies like you mentioned with examples, which it cannot be for a long term. It has to be changed because auditor will not allow if that registration procedure not in comply with the ICAO, although it is made by the national level, it is not possible to continue that way. So I am 100% sure India will take action to correct it or to make it more transparent or more better. I checked on the internet. You can open in the internet the Indian registration process, the airworthiness procedure manual. Everybody can find it. It is a very clear. For me, I made a lot of the registration in my life in the airline business and the aviation industry, and I found this very clear. Maybe in the practice there are some problems which can be arising from national security, national interest, a lot of things, or that kind of things that Professor Sandeep Bhatt mentioned, which has some declaration which is not met with the, but is declared by the Indian government. So what I would like to say to you again, and I don't want to talk much more, the ICAO audit is very objective, very clear. One of the critical elements which always examined the licensing and airworthiness and certification issue, now they are there in India, and you can see the result, and you can see the result in the Netherlands, and you can compare, and the comparison is not as. So we have to be very proud of Indian achievement regarding of audit system and the results. Thank you very much.
Okay, so now we have few questions from Ravi. Dr. Ishita Das, she has already answered his question. So Ravi has asked one question to Dr. Tyagi and Dr. Attila. How and up to what extent cryptocurrency facilitate aviation finance, and how we will deal with the challenges of cryptocurrency? So this is the first question from Ravi.
Cryptocurrency was mentioned. I think in aviation industry and in aircraft financing, and Patrick knows much better, he's more practitioner than me. The US dollar is prevailing. Am I right? The US dollar is prevailing. Every business is in US dollar. They are the top. That's why I don't think this cryptocurrency will be the issue.
No, I never heard anything about cryptocurrencies in my entire practice raised as an issue. It doesn't play any role, as far as I know. This is too insecure, and thank goodness, because right now, all these institutions with a lot of risk, everybody warned, they're all falling to pieces. So let's be happy that not in the aviation finance industry it played a role.
And also very high, huge risk, the currency rate. It was mentioned today. The currency rate had very high risk. So you buy 10 aircrafts or 20 aircraft for that certain amount of price, and because of the inflation, because of the changing, you can lose a lot. And it's cryptocurrencies. We know very well how fluctuated the rates, which is, I don't think it is the issue.
Well, it's very simple. That Cape Town Convention, finally, don't forget that countries have been working on such a convention like the Cape Town Convention since 1931. And that took therefore 70 years before Cape Town was realized. In 1931, in Europe, the CITESA, Comité International, what is it called? Technique Expert Judiciaire Aérien, the CITESA predecessor ICAO, already came up with 2 draft conventions for mortgages in aircraft and their registration, etc., etc. And that was the predecessor of ICAO. So it took 70 years to come up with ICAO, Cape Town Convention, endorsed by ICAO. And furthermore, that treaty wants to create security, safety in the sense of safety for guarantee for stakeholders, so the prices go down, and not only favorable for a bank or a lessor, but also for a lessee, and certainly for passengers, because the idea is that the prices will go down of tickets. So how can cryptocurrency play a role as it is so insecure?
But Monsieur TVI Taiga mentioned few things about this in his slides, please.
Just a short addition to the valuable views already expressed with regard to the question. The whole world struggles with the cryptocurrency and the vulnerabilities that it brings in. I think that Government of India is also taking its own time, looking at what's happening around in order to develop a regulatory framework for this. If at all it comes in other sectors of economy, and only when it is tested there, perhaps we will generate a confidence to have it anything to do with aviation finance, where the matter can be very technical. Just one last concluding note with regard to the question itself. Drawing an analogy, there are stock exchanges working on cryptocurrency or crypto technology. So therefore, that is more an immediate challenge for us as to what we are going to do in terms of its regulation. But then eventually we need time to see as to what kind of safeguards are there. Without that, I don't see cryptocurrency playing much role, or for that matter, any role in aviation finance.
The question is now about blockchain. Well, I know that in certain countries, people are talking about blockchain. They're trying to make that established for real estate, right? That kind of stuff. But in aircraft financing, it has never been addressed yet. Yeah, somewhere vaguely, but not seriously. Not seriously. I don't think so. That was another question just popping up. Blockchain.
Okay, so we are running out of time, so we cannot take further questions. I would like to request the participants to kindly mail their questions to the respected panel members. Now, I would like to thank all the members for technical session 2. And we don't have much time, therefore we cannot take a 10-minute break in between technical session 2 and 3. So moving forward to for the technical session 3. In technical session 3, we again have 2 resource persons and 1 paper presenters. Now I would like to introduce to you all the first resource person for technical session 3, Professor Laura Pirelli. She is the founder and name partner of the leading Italian aviation law firm Studio Pirellini. And she is also a professor of commercial law and air law at the LUISS University of Rome. Ms. Pirellini has practiced aviation law since 1988, providing expert advice to the client across the whole of the international aviation sector, including aircraft finance and leasing, antitrust and regulatory advice, litigation and dispute resolution, employment and corporate issues. She is a committee member of the European Air Law Association and a member of the International Aviation Women's Association. She has been named Italian Lawyer of the Year in Transport Law at Top Legal Industry Awards 2021 and 22. She has also been recognized Global Elite Thought Leader 2028 to 2021, Aviation Regulatory and Recommended Global Lawyer 2028 and 21, Aviation Regulatory, Aviation Continuous, Aviation Finance by Who's Who Legal, as well as Best Aviation Lawyer for Italy by Client Choice Award 2020. Now, I would like to request Mr. Relini to take over.
Thank you, Basha, for this kind introduction. Hi, everybody. It is a great honor to be here with you also virtually. I try to upload some slides. I hope I will be able to. Otherwise, I will ask your support, Basha. Aha. Now, can you see it?
Yes, we can see.
Yes. Okay, fantastic. So my subject today is the title transfer of an aircraft. I know my distinguished panelists, co-panelists have already introduced the Cape Town Convention, but I would like to start with the, I hope I can be moving to the next slide. Somebody took the, okay, thank you. Introducing the definition of the flag country, the country where an aircraft is registered, which we can find in Article 17 of the Chicago Convention, which has been repeatedly mentioned before. So according to the Article 17, the aircraft has the nationality of the state in which the same are registered. Of course, according to Article 18, aircraft can change registration, but it is not possible to hold a double registration. Everybody is aware about the issues which we are facing nowadays with the re-registration of aircraft in Russia and the position which ICAO has taken during the last assembly. So the principle is the law of nationality of an aircraft is where they are registered. The aircraft can only hold one registration. Of course, in the international cross-border transaction, there are many circumstances where an aircraft can be moved from one registry to another, and this is where we have the most challenging activity to be carried on. Please move to the next slide. Thank you. Now, why I said the cross-border transactions are those transactions where we may face more issues. First, for instance, is the form of the contract. Many states, normally the common law state, allow the so-called bill of sale. The bill of sale is a unilateral agreement, whilst in most of the statute law system, such as Italy, Germany, Spain, the unilateral bill of sale cannot be utilized to transfer title to a registered movable asset as the aircraft are. So in our system, you need a bilateral agreement. Not only, sometimes specifically specific countries, again, such as Italy, Spain, and other statute law system countries require also specific form. Normally, the notarization of the signature on the bill of sale or double party agreement, as well as for some countries which are not part to the AIA Convention, also the apostille. So you need bilateral agreement in certain countries, unilateral is sufficient in other countries, you need notarization in certain countries, you need apostille in certain countries. So it is fundamental when negotiating a cross-border aircraft transaction to be aware about all these details. Otherwise, the risk is, and we, for instance, now I'm following a case where there are 3 Boeing 737 grounded in Naples, and nobody knows who's holding the title to these aircraft because they have been deregistered from the FAA by means of a unilateral bill of sale, and they are not eligible to be registered, for instance, in Italy. So they are grounded, there are litigation ongoing, and in this moment, there is no registration of the title, which is one of the worst scenario for a lessor or a owner financier of an aircraft, because the aircraft must be registered in a state, only one as we said, which will also determine all the rule which will be applicable to such aircraft. Then, and the previous panel entered into more detail, we have also the Cape Town Convention, where for the countries which have been ratifying such convention, the owner of the country that ratified can register, but we will see in the next slide that the Cape Town registration to a certain extent has different effect compared to the CAA registration in the nationality country of an aircraft. Another very important point to be examined when you transfer title and you move from a country to another country is whether the deregistration process is very straightforward or rather require certain steps to be accomplished. Many owner lessor who purchase aircraft which are registered in certain registries, such as, for instance, the Italian one, then face issue when it comes to deregister such an aircraft. Why? Because in the Italian legislation, the transfer of register to a non-EU registry is only allowed after a certain waiting period has been passed, which is 60 days. And during these 60 days, any creditor may challenge the deregistration process, claiming their credit to be paid. So this could be a severe issue in certain countries when the deregistration is not, upon simple filing of the bill of sale or bilateral agreement. So I hope all these potential issues are clear, and so we can move to the next slide. Here we, as I promised, very quickly go through the different effect of nationality registration when it is with the Civil Aviation Authority. For instance, in many systems, registration is in the name of the owner. In other systems, like Austria, ownership is not recognized by registration. In other registries, such Ireland, the aircraft can be registered in the name of the operator, and the owner is just mentioned, but it is not a recognition of title. In Spain, you have two registers. One is the register of movable asset, whose purpose is certifying the ownership. Another one is the operator aircraft registered. And as we said, the registration with Cape Town has a different purpose, which is a different characteristics, which is the one of reflecting interest on an aircraft, such as also on part of the aircraft, for the purpose of protecting such interest. But it is, as we said, going in parallel with the other effect of the CAA registration. Another effect of the CAA registration is to assess liability. There are many, unfortunately, accidents happening, and only if the helicopter or the aircraft is registered properly, you can assess who's the operator, who's the owner, what is the insurance, whether they were fulfilling all the registration and insurance obligation, and then state the family of the victim or other third parties rights and the entities which are liable for such crash or other effect. So again, it is important to assess the process of deregistering, re-registering in the countries of the nationality country, as well as Cape Town, if the country is adhering to the Cape Town Convention and having the different impact on local requirement and liabilities. Again, I hope the slide was clear and you can read it, and so we can move to the next one. The next one, I'm afraid you need to expand a little bit because it is not readable otherwise. This slide has been issued by ICAO and it is trying to assess, it's not, thank you, for maybe you should put at full screen so maybe our audience can see it. But anyhow, of course, you can then get the entire presentation, you can read better. Here is a very useful, I find it very useful scheme, which has been issued by ICAO. I'm sure that many of you are familiar with, which try to enter into the details of what step you have to undertake for the transfer of title when it involves a cross-border transaction, starting from assessing whether the registry will change. If it is not changing, you go to the orange box. If it is changing, you proceed with the white boxes, and there are all these steps, as I said, involving what kind of registration of certificate you need, what kind of export document you need, because on the left side, as you see, we have the requirement under the exporting state, whilst on the right hand we have the requirement under the importing state. In a nutshell, first of all, you have to get the proper documentation from a technical viewpoint. For instance, if you were to export from the United States, you need to have a certificate of awareness for export from the FAA, but this sometimes cannot be sufficient to go to a EASA register, because I'm sorry, I hope I don't go too much in detail for our audience, but it is important to know that besides all the other requirements from a legal viewpoint, when you happen to transfer the title of an aircraft from a system which is governed by, for instance, FAA, but the same applies to India, China, so non-EU system, non-EASA system, it can happen that the technical requirement of the aircraft comply with the technical rule of such country, okay, but they do not comply with the requirement of a EASA country. I had an experience where a Challenger aircraft, 604, I believe, were stopped in Austria seeking for EASA European registration, either Austria or Italian, because the air conditioning system had been modified since the manufacturer release, and the modification were approved by FAA, not compliant with the EASA requirement. Then the purchaser, being an Italian entity, had to redo all the air conditioning system, complying with the EASA requirement, and this led for the aircraft being grounded 1 year, and you can imagine the cost. So again, when you have to assess the eligibility of an aircraft in a cross-border transaction, you have to take care of all these details. So not only the aircraft must hold the registration from the exporting state, but this certificate must also contain detailed reference to maintenance which are eligible for re-registration to the other state. Other essential check to be made before the sale be completed is about VAT and custom duty on both sides. In export side, do you have to pay any custom duty, any VAT? On import side, because as well there are different rules, even in the European law system. Do you know that most of the aircraft operating in Italy...
Ma'am, sorry for the intervention, but I would like to request you to conclude.
Okay, I'll just close by saying that, for instance, in the European system, despite we have a uniform directive, many aircraft are registered passing from Ireland. Why? Because Ireland recognizes the VAT rule on the end user, whilst other countries like Italy do not recognize such rule. So to conclude, title transfer when involves more than one country is very complex exercise which require a series of assessment and previous check to be made. Otherwise, there could be a risk of invalid transfer if the title is not complying with the law, the applicable law, the risk of a technical issue if the aircraft to be transferred doesn't comply to the country of registration system, and also VAT customs duties problem. Thank you, and sorry if I have exceeded my time, Basha.
Thank you so much, Ms. Pirellini, for the wonderful presentation. You have discussed the legal issues related to title transfer and the problems. So thank you so much for such wonderful presentation. Now, I would like to welcome our next paper presenter for the day, Mr. Saurabh Sood. He is an assistant professor of law, School of Law, Bennett University, New Delhi. He has submitted his PhD thesis this year to National Law School of India, University, Bengaluru, in March 2021, not this year, sorry for the mistake. So now I would like to request Mr. Sood to please take over the mic and give his presentation. And again, I would like to request to all the paper presenters to kindly maintain the time because we are really running out of time. So, Mr. Sood, am I audible? Is he in the meeting?
He's in the meeting, but I guess he left.
He left? So, okay.
So there might be some technical issue. So you go ahead with the next resource person. I think if he joins in between, then he can go.
Okay. Sorry for the problem. Right now, I would like to introduce to you all the third and the last resource person for this technical session 3, Dr. Andrea Trimarchi. He is a researcher of aviation law in University of Cologne, Germany. Andrea Trimarchi is currently a legal advisor and research assistant at the University of Cologne, where he teaches air law and international law. He holds a PhD in the aviation law from University of Cologne and an advanced LLM in air and space law from Leiden University. He graduated in law in 2014 from the University of Roma, Italy. Andrea is the author of numerous scientific contributions in the area of aviation law, aviation and space law, and also international law and competition law. His most notable publication being the monograph Fundamentals of International Aviation Law and Policy and Aviation Labor Law, Current and Future Perspectives under International and European Law. So now I would like to request Mr. Andrea to take over the mic.
Good morning. Can you hear me well?
Yes.
Thank you. So first of all, thank you, Dr. Sandeepa, for the kind invitation. I'm very happy to join this interesting panel. As far as I could attend the previous speakers. I think that they were already quite keen on giving a broad overview of the Cape Town Conventions and the main criticalities of aircraft finance. Shall I put my slides on, or can you do it for me?
If you'd like to try, you can do it. Otherwise, it's ready here. Yeah. So yeah.
Okay. Yeah. Here it is. So as I understood that we are running out of time, I will try to be quite brief and give you some overview on dispute resolution and aircraft financing. So what I first shall start with is that, as mentioned before, Cape Town Convention has been critical in giving safety and security for stakeholders, our Dr. Honebier mentioned, to lessors, lessees, passengers, but also in providing a clear time-bound remedies relating to repossession of aircraft and engines. It permits the creditor to offset unpaid contractual obligation by immediately repossess or selling the concerned aircraft. So it brings speed in a certain way, certainty, cost saving to repossession, the registration, export of aircraft, helicopters, and aircraft engines. If you can go to the next slides, I'll just go with the next one, thanks. Just quickly on the remedies that are provided by the Cape Town Convention internationally, and they are available to creditors in the event of default of the operator with regard to the repayments of the contractual obligation. So we have a set of remedies for charges, conditional sellers, and lessors. The mechanism to make an application to the court and the lesser right to request relief originates from the documentation of the lease. So we have that the conditional seller has the right to terminate the agreement or take possession or control of the aircraft object, according to the Cape Town Convention, of course, or the deregistration and export and physical transfer to the aircraft object. The charges are similar options, so to take possession of control of the aircraft, to sell or grant a lease, or to actually collect or receive the income from the use of that object that is currently under in the matter at hand. The next slides, I speak briefly about the regime regarding insolvencies, which is a bit different and gives two alternatives to the creditors. So the first alternative, which is broadly relating to the waiting period, so if the insolvency debt or the debtor is unable to cure all the defaults and agree to perform all future obligations within a waiting period, then the debtor must give the creditor the opportunity to take possession of the aircraft by the end of that waiting period, which is, by the way, defined on a national level. The alternative B is quite similar, but the crucial difference is that the local courts regulate whether and when and on what terms the creditor can take possession of the aircraft at the end of the waiting period. Going forward, we go to speak briefly about the IDERA regime, which, as mentioned before, is critical for the quick repossession and the re-exportation of the aircraft. So, as mentioned before, the Chicago Convention states clearly that a civil aircraft cannot fly unless they are registered at a civil aviation register of a country, and that the registration must be exclusive. So an aircraft may only be registered in one state at a time. In this slide, a creditor's ability to repossess the aircraft is quite limited in a sense that it shall first register the aircraft from the other country. And IDERA, which states for irrevocable the registration and export request authorization, is quite effective in allowing the creditor to the lessor, for instance, to re-register the aircraft. What is important in the IDERA regime is that the transaction document must be that accompany the transaction must be reviewed in order to see whether there was a default whether all the necessary feelings were perfected. And the transaction document shall describe the circumstances of the lease, the consequences of the default. Going to the jurisdiction, so Cape Town Convention has an entire chapter dealing with jurisdiction. I mean, the convention, as I put in my slide, does not itself contain a uniform conflict law rules, but it provides a freedom to agree on the jurisdiction. So the parties to a transaction are generally rather free to agree on jurisdiction. However, the selected jurisdiction must be exclusive. It is, however, also an option to the parties to agree that the jurisdictions should not be exclusive, but where exclusive, Article 42 is the applicable one. The choice of law actually gives also the possibility to the parties to submit the claim to arbitration. That's what I'll be speaking about in the next slide. If you can go to the next slide. I talked about IDERA already. Sorry, next slide. Yeah, so we all know that as aircraft finance involves high value assets and lessors, lessees, everyone in the industry has the necessity to have a quick solution of any dispute that may arise. Arbitration is actually quite common. This is for a few reasons. I mean, I mentioned only a few, which is confidentiality, because most lessors are listed national stock exchange, fast resolution, because sometimes going to court involves some burdensome proceedings, and getting an enforcement order from a national court may be quite difficult. In this regard, I want to speak about a few case studies, let's say, so whereby it has been a common understanding in Asia, for instance, in China, to go to friendly jurisdictions. So Hong Kong, for instance, has been named as one of the safe seats for arbitration in the recent years. And one very important study, one very important case that was discussed in 2021 involved an Indonesian carrier, Garuda, and a lessor, and the claim was brought to the attention of the English court. However, there was a dispute. There was an arbitration clause that in the contract, in the transaction, claimed that any dispute arising out of the lease agreement would have been resolved by arbitration. What is very important is that it seemed that in the contract there were two conflicting provisions. So one went for arbitration, and the other one provided the option to the lessor to go to court. And the court actually clarified that there was an arbitration clause, and that would have been prevailing. This is quite important because even the carrier, Garuda, in that case, did not dispute any substantial matter. So they did not dispute debt or the failure. They challenged the jurisdiction of the court because the reference to the court was likely, in their view, a mistake, and the determination of the default should have been referred to the arbitration in the first instance. So as we see, going to the next slide and maybe drawing some conclusion, I mean, mine was quite of an easy overview, but it is important that in the context of dispute resolution, we have a conflict of private laws. So whereas the jurisdiction options provided in the Cape Town Convention allows for quite a high degree of flexibility, it is also important to understand that we have a very high international market with lessors based everywhere and lessees based everywhere as well. And it's also important that when the parties decide to go for arbitration, they must be sure that the judgments are recognized in the country, in the enforcement country where the aircraft is based and where they have to repossess it. Some countries would recognize quite easily arbitral awards. especially those of international arbitrators, but still this does not happen in all cases. Drawing some conclusions to the next slide. So repossession, as we have seen, is not an easy topic. So it always provides many options for the lessors and many issues that on a practical level will occur. It may be quicker at times, as we have seen in the case I mentioned before with the Indonesian carrier, to get an interim relief from arbitration, because enforcement orders in national courts take quite a long time. And it would be probably necessary to have an easier and faster recognition of foreign judgments, especially because we have seen many countries, I don't know, for instance, Russia does not automatically recognize foreign judgments or for decisions from arbitral awards. So this is important all in the optics of an industry that is based on highly valued assets, which have to move easily, faster, and to give certainty. Now to come back to my very first introduction point about the safety and security for stakeholders, the investors and the lessor and the lessees have to have security and safety, especially after the COVID pandemic highlighted the difficulties of a highly international world being stuck for certain circumstances. So this might concludes my presentation, and I'm very happy to have the chance to join this interesting panel.
Thank you so much, sir, for your kind words. You have provided a very good information regarding the dispute resolution system in aviation financing. Due to some technical issues, we have lost connection with Mr. Saurabh Asood. So without wasting further time, I would like to request all the participants for the question and answer round. We are open to take your questions. Now you can put your questions in the chat box. So all the participants, I'm requesting you to put your questions in the chat box.
So they can also ask, if they want to ask, they can also ask directly. Unmute yourself and ask. Yes.
You can also ask directly.
May I start?
Yes, please. Yes, please, Professor. Yeah.
All right. About the arbitration, interesting, Mr. Tsimaki's presentation. Arbitration. Recently, in fact, a couple of months ago, there was created, let's say, an aviation arbitration court in The Hague in the Netherlands. All right. And that is, of course, glorious and glamour for the Netherlands. But my question is, however, where do you get proper arbitrators in this very specialized area of law, aircraft financing and leasing law? Where do you got real good arbitrators? Because it is a very closed society, not many people. And then the people operating, lawyers, they are not always good lawyers. They pretend to be international aviation finance and lease lawyers, and they work for the largest law firms in the world that do corporate law, mergers, acquisition, and then on the side, for example, with all due respect, they do also aviation to make a buck or two. Now, I have very bad experiences with arbitrators in the sense I'm not that 100, but that I think the arbitrators really, they had no clue what they were doing. Honestly, they were not. And of course, judges also in general are not familiar with this highly specialized area of law. But certainly arbitrators, which are supposed to be experts, I mean, where does that organization now in The Hague, which I think, okay, wonderful, and it is originating from Hong Kong, the guy who was the engine behind it, I think we all know he has his office these days already a long time in Hong Kong. And in Asia, as you said, yeah, arbitration is traditionally already viewed as the best way to dispute resolution. But in essence, therefore, where do you get these arbitrators which are satisfactory, which really know about aircraft financing leasing laws?
Andrea, do you want to start? Because I have some comments.
Yeah, well, I mean, just very quickly, and then Laura, you can, of course, continue. You're totally right. Arbitration in an ideal world would be an easy and fast solution. Of course, it depends on who is arbitrating the dispute. And you're very right when you mentioned the Hague International Arbitration for this particular disputes. We may hope that in the future, I mean, given that we have an institution that is dedicated, expertise will increase. So with professors and not only lawyers will sit in those arbitration. But as you rightly pointed out, also when you go to court, I mean, judges have no clue most of the times, because we are talking about very sensitive and very, I mean, these aircraft finance is a very sensitive and difficult subject for even the experts themselves. So imagine a judge who has been doing totally different things until the day before. This is an issue, yeah, of course.
And another issue is money. It costs a lot of money. And finally, do other countries will pick up the reward, arbitral reward, yes or no? Or do you have to go back to court again and litigate? That's another risk which is always there.
Patrick, if I may, in fact, in Europe now we are facing, and your question is very good to this extent, we are facing a big issue, and this may be the reason behind the setup of a court, arbitration court in The Hague. Why we are facing an issue? Because most, as you know, of the litigation arising from aircraft financing or transfer of title were referred to the UK courts, okay? Because the UK court are the most, I wouldn't say expert in specifically aircraft financing, but in the governing law, which is and was generally governing the aircraft financing around the world, either UK or US. Okay, now after Brexit, and I'm facing huge problem for the exequatur, the UK judgment are not anymore enforceable in European countries because the regulation 1165/2012 is not anymore applicable. Therefore, if you get a judgment in the UK and want to enforce in France, Italy, wherever, you need to pass this exequatur proceeding, which in Italy, for instance, may require 1 year. And this is an issue. Now, what could be the court superseding the UK court? What is the advantage of the UK court? They were very expensive. You raised the point of arbitration being very expensive. Court in the UK, if you go through an entire first degree in the UK, you spend no less than £500,000, no less, each party. Okay? So it's tremendously expensive. But the advantage of this country is that they are very straightforward in the law. So these agreements are 100 pages, okay? And they govern every issue. The UK law judge apply, if you say, despite the aircraft is not serviceable, the lessee has to pay. For the UK, this is applicable because the financier doesn't know about the serviceability of the aircraft. In Italy, this rule would be against the public order, and so and so and so. So we miss now jurisdiction which, due to the cost, was deterring the litigation on the one side, and if litigation were made, was able to apply the regular governing law of this kind of transaction, eventually designating expert, because they can designate the expert. So in the common system, it's more, it's more common to use jurisdiction such than arbitration. But I agree with you that now that there is a specific venue for arbitration, we have to see whether people there is really expert, because they must be expert exactly as you said in aircraft financing, which is not so common, because many lawyers, as you said, do M&A, merger, acquisition, blah, 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 not specifically aircraft financing.
Laura, great to see you, but to see you again. And thank you for your comment. But you see, I have never been an admirer of English courts and their rulings. Look at the Blue Sky Mahan Air case, 2010, 2009, which were totally dreadful for the entire aviation finance lease community at large, global. It was dreadful, and it was also because the court, what can a judge do? It listens to the parties arguing, the barristers and the solicitors, and from the advice from the Netherlands. And all these lawyers made the most biggest mistakes. So, and that's only one case. Also the case, the Olympic case about, what do you call it, high water, hell or high water clauses. That has not reached the Supreme Court of England yet. But I mean, those kind of rulings are absolutely ridiculous, ludicrous. I mean, but okay, arbitration. Let's wait and see. Indeed, let's wait and see. But right now, honestly, I cannot say, okay, this is it. That's my conclusion.
So Tanmay has raised his hand. I think he has some questions. Tanmay?
Yes. So when it comes to enforcement of arbitral award, another issue that crops up during this is that almost always the losing party challenges it in the court. The arbitral award itself, they challenge it in the court, and almost always, this leads to further delay in the enforcement of arbitral award. So, is there any way that we can address this issue and help in better enforcement of arbitral awards? Because the losing party always challenges it in the court, and if they lose there, they challenge it in the court of appeal, then go to the Supreme Court. So this leads to the delay in enforcement of arbitral awards. So is there any way that we can address this issue and help in enforcement of arbitral
awards?
Did you ask about the challenge? Sorry, because at the very beginning, Tamay, I don't know my colleague whether you got all the question. The very beginning, the line was very bad. I got at the end that you were asking whether there is a mean to address the fact that those decisions can be challenged. Is this the question? Sorry, to be clear.
Yes, ma'am. The question was that almost always the losing party in the arbitration challenges the award in the court. And even if they lose in the lower court, they challenge it in the higher court and then go to the Supreme Court, etc. So it leads to the delay in enforcement of arbitration. Is there any way that we can address this issue and help in the better enforcement of arbitral award?
I try to answer, but then I leave the floor to Patrick and Andrea. Of course, there is a way, but that the party normally do not like, which is to make the arbitration not subject to challenge. It is possible. So it could be one shot. Then you have the question of enforceability, but this is another story, okay? So the first and best way would be to make the decision of the arbitrators final and binding. But this is also a risk that normally parties and their lawyers do not accept. If not, you are right. And Patrick made this comment at the beginning. You run the risk to spend a lot of money, stay a long time in arbitration disputes, get a decision which is then challengeable. And therefore, you start another process, which can be also very expensive. But the only way would be to make the arbitration award final, binding, not subject to appeal. I don't know whether my colleagues agree. Patrick, you are on mute.
Sorry, I agree, but I don't know what else to say, and I don't know whether our colleague Tim Markey has to comment on this, because.
Well, there is I think, very little to add what Laura said. You're right. The only possibility at the moment would be to make the final decision of the arbitrators binding, let's say, so not challengeable. We may hope that probably the Aviation, The Hague Arbitration International Court in the future can be seen as the final decision maker in that respect. So, but this is a long process, I think, and I don't know what you all think about it. At the moment, I think that that's the only problem, the only option. So.
Just to add on to that, I think actually the Tanmay's question crops up primarily because of the position in India. We have a very, very, very bad precedent in terms of actually challenging the arbitral awards. And even if actually the parties have agreed to make it final and binding, still that has been actually opened up by the courts actually. So yeah, it differs from actually the country to country. European experience is definitely much better than the Indian experience in terms of the enforcement of arbitral award. But yeah, of course, maybe we may have to follow it up in the course of time. Especially with respect to enforcement, actually. Yeah.
Okay, so we don't have any further questions. So now I would like to request Dr. Sandeepa Bhatt to address the audience and to give the valedictory a vote of thanks. Over to you, sir.
Thank you, Basa. So we are well within time now. Yeah. So I just have to express the vote of thanks. In fact, actually, when we started working on this particular conference, almost more than 3 months back, because everything started at that time, the initial brochure, everything has been prepared more than 3 months back itself. I had a question about the feasibility of pulling off a conference on the aviation financing and the UNIDROIT system. Because as all of us know, it is very few experts who work in this particular area. And in India, it is completely actually Patrick was basically referring to that. Even the Indian judge did not even refer to the UNIDROIT system when actually the decision was made. So that is the kind of actually the knowledge which we are having with respect to the UNIDROIT system of the aircraft financing. So that's why I had doubt with respect to whether we will be able to pull off this conference or not. And that too, it's a one-day full conference. So it's not just a workshop of maybe 2 hours or something like that. So full day's conference. So yeah, the doubts were the more in terms of actually having it. But I should be really thankful to all the resource persons because when we opened up for the paper presentation, we called for abstract. Just usually, as we do normally for all the conferences, we called for abstracts and we gave 1 month time to submit the abstract. We only got four abstracts. This is the first time that we are getting 4 abstracts. But every other conference, we used to get at least 50, 60 abstracts, and we had to pick best of actually the 5, 6 out of that. We just got 4 abstracts. This is the truth, right? Because nobody works in this. Nobody want to venture into this field because it's super specialized the aspect. Out of that, somehow we have picked 3 of them, and you can find that today, out of the 3, only 1 presented. Remaining 2 were not even there. I don't know what was the issue. Was it technical or was there something else? I'm not very sure about it. But that is the scenario with respect to the aviation financing. So I should be really thankful to all the resource persons who could take their time and then actually come forward. My special thanks to Hamza, Professor Stephen Truxell, Dr. Attila, Aditya Warrior, Professor Patrick, Divya Tyagi, Professor Laura, Dr. Andrea. I think the best of the best in this particular the field of aviation financing, both from the academic point of view as well as from the practitioner's the point of view. I think this day belongs to all of you, right? So you could able to make it successful. So I should thank all of you for this success.
Did you now say that there was still time left or not enough time? What was it now for questions?
Pardon me? Sorry?
Did you say there is not enough time, finished, we have no more time? Or did you say there was still time for...
There was still time. I said there's still time because we could able to...
And I have a comment.
Yeah. I said we still have time. Especially those paper presenters did not appear. So that's the reason why we still have some time. That's what I told actually first time. Yeah.
Okay,
right, so,
my comment is because you mentioned that unfortunately some presenters for whatever technical reasons couldn't make it, and I was actually looking forward to our colleague from Bologna, Anna Masuti, Professor Masuti, because her presentation was called "Difficulties of Civil Law Countries in Ratifying Cape Town." That was her. And I was very much looking forward to that. I was thinking, what is she going to say? But she is not going to say anything. So I've raised an issue for all of you, because first of all, this title, Difficulties of Civil Law Countries Ratifying Cape Town, well, I think you mentioned that already earlier a bit, Attila, that, or maybe you, Laura, that many did, I think you, Laura, many civil law countries did ratify Cape Town Convention. When you look at the entire list of UNIDROIT, contracting states, there are, I don't know how many Islamic states, so they are not common law and they are not civil law, so they fall out. But of the remaining one, and I have looked briefly at them, and I didn't make a research or whatever paper, but I think at least 50% of the states ratifying these treaties has a civil law origin. So I don't understand what you say. Why is it difficult for civil law states, per se, in general? Because many have adopted already that treaty. So maybe a few states in Europe, in brackets, they have difficulties. But then I wonder, what on earth is their problem? And unfortunately, Anna, our colleague, wonderful colleague, knowledgeable, very knowledgeable, that she isn't here. But that's what I wanted to comment. I mean, that civil law states have a problem, 50 or whatever, or no, let's say 40 already have. So,
Patrick, I cannot get in the shoes of Anna, but but I'm blonde and Italian as well, so I know something what she wanted to say, because we are in the same group of person working with the Italian CAA and Minister of Transport to move forward with the ratification, which was because Italy was one of the signatory of the Cape Town Convention, as you know. What has been the obstacle? Sorry if I take 1 second. In our process, as Andrea knows, maybe in Germany is the same, or I don't know, in other statute law system is the same. When you have to ratify a convention, then there are several opinions requested by law, for instance, in Italy to the Minister of Justice. And last time, when Cape Town was submitted for ratification, the Minister of Justice raised 1 point for the full ratification with the declaration of enforceability, etc., coming from our bankruptcy law, which is public order law. In other words, in case of insolvency in Italy, the lessor cannot repossess or advance any claim unless with the consent of the trustee and to the competent court, which is the court of the bankruptcy. Okay, this is a serious issue for the full enforceability of Cape Town, which was raised years ago by our Minister of Justice. We are now trying to move forward to find a way to change this rule and make Cape Town compatible with the internal rule. So I really don't know, maybe Anna has studied better what other countries can face the same issue. Spain has ratified, Germany has ratified, and so and so. So there are civil law systems which have ratified. In Italy, we faced this problem, but now we are at an advanced phase, thanks also to UNIDROIT, and we need to move forward with some ideas on how to make compatible with the internal rule. I hope I've been clear in answering your question.
Yes, I understand that. And insolvency is always a very sensitive kind of area. Also in India, what our other presenter India was talking about, insolvency in India, this and this. I do appreciate that. And I must say, that the Kingdom of the Netherlands, the Kingdom did adopt the Cape Town Convention already in 2010, except for the European part. All the other parts of the Kingdom, territorial units, it is applicable. And if you are a bit wise, you can still have it applicable in Europe also. Yeah, it's very easy. But one of the issues was the insolvency. It was. And therefore, the Kingdom of the Netherlands did not make that declaration, as you say, Laura, because, oh my goodness, there was such a resistance here, and you know very well by whom particularly. I don't have to mention his name, and Attila knows him also, but from the Leiden circles. But that's the only declaration we didn't make. In addition, European countries had issues with the European Union because, the EU said insolvency is European matter, so the countries in Europe cannot make the insolvency declaration a alternative. They just couldn't. But I do appreciate that. But I think right now, as you say, also here in the Kingdom, we are working on making that declaration after all. And actually, it is very strange because our local law in the Kingdom of the Netherlands, where Cape Town applies, the local insolvency laws are more beneficial for the creditors than Cape Town is. They are easy creditors here. Mortgagee has, I don't know, the best rights, better than New York, better than Cape Town, the insolvency declaration. You see, but I appreciate what you say.
No, actually, I was also looking forward for Professor Masuti's presentation. Since I have researched on the common law countries' concerns in terms of the UNIDROIT and maybe the financing aspects, so I was looking forward to the civil law countries' concerns, and it's good that actually Professor Patrick has raised the issue, and then Professor Laura has actually responded to that. So hopefully, actually, we can also hear Professor Masuti with her paper actually. So she's supposed to actually write a paper. She's going to contribute that. Hopefully, we'll also be enriched with her opinion about the civil law countries' difficulties in ratifying the UNIDROIT system. Right. So let me just actually complete my duty here. First of all, as I told you, let me thank all the resource persons wholeheartedly for accepting the invitation and being part of this particular conference. Not just that, igniting the debate, right? So amongst the resource persons, right? So initially, Professor Patrick and Dr. Attila, now Laura, Andrea. So it's great to see that actually. So this is the kind of academic delight for all of us. To have knowledge in this particular very, very specialized area. Thank you so much. Let me also thank our Honorable Vice Chancellor. I have already done that in the morning. But anyhow, so in his absence presently, because now he's in another conference, 3 o'clock, there is one more conference which is going to be inaugurated. He's in that conference right now. He had 3 conferences, but still he could able to make time for our conference and deliver the welcome the address. And he has always been actually a pillar of support for any activity in NUJS. So I thank him in his absence here. Let me also thank all the participants. Without whom it would not have been successful. That too a specialized area. So it has been difficult for us also to have the participants, but still anyhow, they could able to stick to it, and they could, once they have entered in, they have actually stayed back. They have actually heard all of us. And then also they have been actively participating in terms of the discussion. Thank you so much for all the participants. And finally, my team members, it has been a Herculean task for every one of them. I know that working under me is always a difficult task for everyone. So, and that too for a conference like this, which added on the tension with very few expertise in this area, I think they would have really had a difficult task to manage. So I should really thank all of them and a big lot of applause for all of them for making this conference a big success. Thank you so much, and I hope that actually next time we'll meet in person and we will have a physical conference in NUJS. Thank you.
Okay, bye. One final tip. Next time start 10 o'clock European time.
So that is always a difficult task for us because it would be afternoon for us. So it might be a workshop. Otherwise, it would end up in the midnight.
Yeah, but in India, the sun is always shining. So what are you talking about?
Not in Kolkata. Not in Kolkata. It is already dark here almost. So 5 o'clock, it would be completely dark.
Okay. All right. Thanks a lot.
Thank you. Thank you so much.
Thank you. Ciao, Andrea. Ciao, Patrick. Ciao, Attila. Bye.
Bye.
Thank you.
Bye, everybody.
Stanley. Ciao.